Okay. So guys, good morning everyone. I hope you're doing well, studying well, yes, eating well, sleeping well, reading well. I am good, but I am good. Now, yesterday, let's continue with the part. Yesterday finished, we started with discharge of contract, where we studied that there are five methods of discharge of contract, in which we have finished by operation of law, by impossibility, and by agreement. Correct? Now, the first part we have to do, that is by performance. Discharge of contract by performance. Let's understand. Sir, by performance means what? Beta bit both the parties perform the contract gets discharged. Simple as that. That is discharge. But beta, there are two types of performance. One is actual performance, one is tender performance. Now what is this? In both the ways, beta, contract will be discharged. But what do you mean by actual performance? Actual performance means one party performed the contract as per the terms and the other party accepted the performance. Like I told you that, sir, can you give me loan? I will repay the loan after 2 months. You gave me the loan. I repaid the loan after 2 months. You accepted the money, obviously. So basically, I performed what I promised and you accepted the performance. That is actual performance. Contract is discharged. Now, but what is tender performance? Tender basically means offer the performance. Here one person performed the contract as per the terms of contract, but the other party rejected the performance. That is called as tender performance. Am I clear with this? So one party performs as per the contract and the other party rejects the performance. Contract comes to an end. But here the contract is not performed properly because one party performed, other party did not accept. So here, which party? It's kind of breach. So which party can file a suit on which party? Answer: the party performing, okay, can sue the party rejecting the performance if certain conditions are fulfilled. Okay. Now, what are the conditions to be fulfilled? Let's understand. We'll take an example and understand. Say example: your college was there and your college fest was there, and you wanted one dancer to come and perform. So you decided you will call Nora Fateh to dance. Okay, correct. Now you want her to dance on which song? Do you have any idea which song you want her to dance? Any idea? No. So basically, example, you wanted her to to dance on Dilbar. Okay. So basically, what you did, you showed her video to your trustees or principal. They are like, okay, she's a good dancer, we'll call her. You called her and you told me you have to dance on Dilbar song. Okay, Dilbar, Dilbar. She came and she danced on Dilbar song. Now, when her manager goes for payment, your college principal is like, "Maja nahi aaya. I didn't enjoy it. Okay, it was not with energy. So, sorry, will not pay you." Basically, one party performed, other party rejects. Basically, can Nora Fateh file a suit on your college? Answer: if certain conditions are fulfilled, then yes. Let's see the conditions, whether it is fulfilled or not. Caliber of party performing was inspected. Very good. You showed the video. Opportunity of inspection was provided, that whether she performed as per the contract. Performance was as per the contract, yes. And she performed in front of everyone, yes. The other party rejected the performance. So all the four conditions are fulfilled in our case, yes. So Nora Fateh can sue your college. Okay, clear? So this is that point. Now, sir, the question comes: who can demand performance? Answer is, beta, in case I told you, sir, give me loan, I will repay you the loan on time. So from me, who will claim the repayment? Answer is, beta, you can claim. If you have authorized agent, they can claim. Or basically your legal heir or representatives can claim. Yes, in case you die. But next question is, from whom performance can be demanded? That is important. Answer, or who should perform? It depends whether the contract is based on skills or it is not based on skills. If it is not based on skills, like example, I have to repay the loan, so where any skill is required, as you just have to repay. Am I required to better a dance and like you? No, obviously no skills are required. So basically, can I repay? Yes. Can my friend come and repay? Yes. If I die, can my legal heirs repay? Yes, obviously. You are concerned with money. But if a contract is based on skills, then only that person should perform. Like beta, Nora Fateh came and told that she'll come and dance. So Nora only should come. If Nora is not available, can her sister Dora come? No, obviously not. It is only Nora who should come. Am I clear with this? Okay. Now, just now, so I hope you understood this part. Now the next part. What does the next part tell? What is there? You might get a question distinguish between assignment and succession. Generally, they would not ask now, but probability is that they might ask. So assignment means what? Transfer. Succession means also, but it's also transfer. What is assignment? Assignment is by that is called as transfer by agreement, by contract. Okay, like I buy contract, I have a contract. Okay, like example, sale. I'm selling you this wallet. So basically, that is assignment. Okay, transfer of ownership by agreement, by contract. Simple. But succession is also transfer only, but it is by operation of law. Like if I die, who will get my properties? My properties will be transferred to my legal heirs, but that is by operation of law, no contract. Can assets be assigned? Yes. Do assets succeed? Yes, assets do succeed. Other can liability be assigned? Answer is liability can be assigned. Like I take loan from you, okay, and I have to repay you. Then I tell you, do one thing. I tell Mr. X, okay, you repay my loan. So basically that is assignment of what beta? Take a liability. That can be done. Yes, I can transfer my liability to Mr. X, but only with the consent of creditor. If creditor doesn't give consent, I can't do it. Okay. Liability can be assigned provided creditor gives consent. Sir, can liability succeed? If I die, my asset goes to my legal heirs. Will my liability also go to legal heir? Answer is yes, but only up to the value of asset succeeded. Like if I died, basically I had asset of 1 crore, liability of 1.1 crore. Liability of only 1 crore will go to my legal heir, not 1.1 crore. Am I clear with this? Understood? Clear? Yeah. Now, joint promisor. This is very simple. Section 42 to 44. Sir, if A and B jointly take loan from C, A and B who will be liable to C? A and B both. If A dies, then A's legal representative plus B will be liable. But A's legal representative will be liable only up to the value of asset succeeded to him, not more than that. Sir, that B also dies, then who will be liable? Beta, both legal representative, both A and B will be liable. Sir, section 43. Sir, A and B have to pay C now. So basically, sir, can C tell B, you pay the entire debt, I want money from you? Answer is yes, because A and B are jointly and severally liable. Jointly means both, severally means individually also they are liable. So they are both liable. So C can compel one party to pay the entire debt. Now what does section 44 tells? C can discharge one party from paying the debt. C can tell A, you don't make the payment to me. Okay, you are very elderly person, you don't make payment, I am discharging. C can discharge A and take the entire payment from B, yes. But here example, the loan was of 1 lakh. So actually A had to pay 50, B had to pay 50. Now entirely B will pay to C 1 lakh. But A has to pay his 50,000 to whom beta? B. Am I clear? Understood? C can discharge one party from paying the debt, but such discharge party is liable for his proportion to the other joint promisor. Am I clear? Next, joint promises, section 45. Now what is joint promising? Joint promising means A took loan from B and C jointly. So A will be liable to pay B and C, very simple. If B dies, A will be liable to pay A will be liable to B's legal representative and C. C also die, then A will be liable to pay legal representative to both B and C. Simple. Section 45. Done. Everyone? Anyone has doubt? Clear? Good. Now section 46 to 50. Sir, in a contract, one party offers other party has to give acceptance, offer an acceptance. But sir, if I made an offer that okay, I will do this thing for you, but within what time I have to do, at what place I have to do, during which hours I have to perform for you. If the law is silent, if the contract is silent on that, so within what time you will perform? Like example, if I am a writer, I write movies, stories for movies. Producer came to me and he told, will you write a movie for me? I told, okay sir, I'll write a movie for you. Or I went to a producer's house. I told, okay sir, I have a good movie, I have a good story, I will write the story for you and give it to you. It's like, okay, but sir, within what time I have to give it, within what time I have to give the story? Okay, at what place I have to give the story? Okay, nothing is mentioned. There, beta, section 46 to 50 comes. You see, day, time and place of performance. Sir, if any day, time and place of performance is mentioned in the contract, then I have to perform as per the terms of contract, whatever is agreed. But if it is not mentioned in the contract, so there are two things here. Promisor undertakes to perform himself, promisor does not undertake. Like I told you, boss, okay, that I will give it in writing to you. I'll give the story in writing. Or I'll write, example, I'm a lyricist, I'll write the lyrics of the song and give it to you. Okay, but I did not say ki it is my responsibility to contact you, take care and give it to you, take care within the proper time. Nothing. I just told, okay, I'll give it to you. I'll give it in writing to you. No problem. I'll give the lyrics, I'll give the story, whatever it will. Okay. So now who wants it better? Take care. You want it. So I'm the promiser, you are the promisee. And I have not told anything, I'll contact you, I'll be in touch with you. Okay. No, I am not taking responsibility of anything. Then beta, you have to coordinate. So here, promisee shall give directions. At what time, within what time, at what place, during which hours you want it. Then I have to perform it like that. But sir, if I have told sir, I'm a newcomer, I'll take care of everything, I'll be in touch with you, okay, you will get it on time. I am only telling everything. Then beta, if day is not mentioned, so I have to perform within a reasonable time, section 46. Time is not mentioned, so I have to perform during business hours. During business hours, I have to come and give it to you. But place is not mentioned. So here I have to call you and ask you which place I have to give it. I cannot give it at a reasonable place. No reasonable place is a reasonable place. So basically, I have to call you and ask you, sir, at what place you want. If you tell me come in the office and give it to me, then beta I will give it. Am I clear? The promisor shall inquire about the place from promisee and perform accordingly. Am I clear with this? So section 50, if anything mentioned in the contract, perform accordingly. Section 48, okay, if promisor has not undertaken, nothing is mentioned in the contract and promisor has not undertaken anything, the promisee should give directions and promisor should perform accordingly. Sir, if promisor has undertaken to perform, he has to perform within reasonable time during business hours, and place he has to inquire from the promisee and perform. Did you understand clearly? Good. Now, now the next point is reciprocal promises, which I will do from JKC book itself. See, reciprocal promises. Now, what is reciprocal promises? Understand. Sir, a reciprocal promise means promises which form consideration or part of consideration for each other. And without reciprocal promises, there cannot be a contract. Like example, I tell you, I'll sell you biscuit, give me money. So basically, you are telling, okay, sir, you give me biscuit, I'll pay you money. So I am promising you that I will give you biscuit, and you are promising you'll give me money. Now my promise is a consideration for your promise, and your promise is a consideration for my promise. So there is exchange of promises, that is called as reciprocal promises. Am I clear? But so basically, without reciprocal promises, can there be a contract? Answer is no. Section 25 exception is there, but generally no. And there are three types of reciprocal promises. Now, which are the three types of reciprocal promises? Let's understand. Promises which form the consideration or part of consideration for each other are called as reciprocal promises. Thus, when a contract consists of exchange of promises, they are called as reciprocal promises. A and B promise to each other, promise to marry each other. These are reciprocal promises. A's promise is the consideration for B's promise, and B's promise is the consideration for A's promise. Very simple. Now, sir, there are three types of reciprocal promises. One is mutual and concurrent. Second is conditional and dependent. And third is mutual and independent. What is mutual and concurrent? Mutual and concurrent means these are the promises. I am making you some promises. Okay? We have to perform the promises simultaneously. Okay? And if I do not perform my promise, you will not perform your promise. Like example, you go to a shop to buy shoes. So basically, your promise that you are promising that you will pay money, and he is promising he will give you shoes. Okay. Now both the promises have to be performed simultaneously. You'll pay the money, you'll give the shoes. If you don't pay the money, will you give shoes? And vice versa. Yes. Okay, that is called as mutual and concurrent. Very clear with this? Yes. These are promises which are to be performed simultaneously. That is at the same time. In such promise, if the promisor is not bound to perform his promise unless the promisee is ready and willing to perform his own promise. Simple. Okay. Now, conditional and dependent. Now, conditional and dependent means what, beta? These are the promises. Okay. Given by, these are reciprocal promises, but one promise is performance of one promise is dependent upon performance of other promise. Performance of one promise is dependent upon performance of another promise. If one promise is not fulfilled, if one party does not fulfill his promise, okay, then beta, okay, other party will not be able to fulfill his promise. So it will be like, first you perform your promise, then I'll perform. If you don't perform your promise, I cannot perform my promise. That is conditional and dependent. Okay, one person's promise is dependent upon other person's promise. I will give you example. Example, I told you, you supply wheat to me today, and after 3 months I'll make the payment. If you do not supply wheat to me today, will I make the payment after 3 months? No. So my promise, okay, is to be fulfilled immediately now? No. Simultaneously? No. But to perform later, but it is dependent upon your promise. One more example. I wanted loan from you. So you told me, sir, you have to give security first. We will value the security and then give loan. Now, unless and until I give security, okay, will you be able to give loan? No, simple. That is conditional and dependent. Am I clear? An example, I am ready to perform my part of promise. Okay. And you are not I performed my part of promise, or I'm trying to perform my part of promise, but you are not ready to perform your part of promise. So any loss to me, I can recover from you. Okay. So see. These are the promises where the performance of a promise by one party depends on prior performance promise by the other party. In such promises, if the party who is bound to perform his promise first fails to perform it, then he cannot claim performance from the other party. Moreover, the defaulting party becomes liable to pay compensation to the other party for loss suffered by other on account of non-performance. Am I clear with this? Right. One more example I'll give you of loss. Mr. A is there, Mr. B is there. B has a ship. So A hires his ship, okay, and tells him, I will bring my goods on port, Kolkata port. Bring your ship and I want to export it to Mauritius. He told okay. Now this guy went to the port, but A did not bring the goods only. So now can B perform his promise? No, obviously not. But whatever cost he incurred from before bringing the ship to A port, okay, A port. So basically, can he claim that expenses, damages? Yes. Good. Third is mutual and independent. See, mutual and independent means here there are two parties who have entered into contract, and both parties have to perform their contract simultaneously, irrespective whether this guy performs or not. This guy has to perform. Have I clear? Like example, A and B start their own classes and CA foundation classes, 4 subjects. A will teach 2 subjects, B will teach 2 subjects. Now fees for that example is 100 rupees for CA foundation. Okay, 50 rupees A will take, 50 rupees B will take. But out of this 50-50, students have paid 25-25. Now A is teaching, he is finishing his syllabus and all. Okay, B is not doing anything, he is silent. But irrespective whether beta he is teaching his subjects or not, A has to teach his subjects. And A completed the syllabus, B did not. So students did not pay this rest 50 rupees. But out of this 50 rupees, 25 was belonging to A. He did his job. But just because B did not do his job, A is facing loss. Can A recover this 25 rupees from B? Answer is yes. Am I clear with this? These are promises where each party must perform his promise independently, without waiting for the other party to perform his promise, or without waiting whether or not the other party is willing to perform his promise. In such promises, if either party fails to perform his promise, the other party may proceed against him for that. Am I clear? Very simple. Now, this is important. Reciprocal promise to do certain things that are legal and also certain things that are illegal. Now beta, if I tell you that I'll do 2 things for you, one is legal and another is illegal. Okay, so basically the legal part will be performed, the illegal part will be void, obviously. Okay, so see what is this? Where persons reciprocally promise first to do certain things which are legal, and then secondly, under certain specified circumstances, to do other things which are illegal. The first set of promise will be valid, but second will be void. Obviously, illegal things I cannot do. See, there is an example. A and B agree that A will sell a house to B for 5 lakh, and also that if B uses it as gambling, he will further pay a sum of 7,50,000. Okay, so basically A and B is like A will sell the house to B for 5 lakhs, but if B is going to use it for gambling, then 7,50,000. Basically, which contract can be enforced? 5 lakh wala contract, 7.5 lakh cannot be enforced only, it is void. The first set of reciprocal promise, that is to sell the house and to pay 5 lakh for it, constitute a valid contract, but object of second being unlawful is void. Next is alternative promise of one branch being illegal. Like example, I am doing a contract. In one contract, but there are two activities to be done. One is legal, one is illegal. Now, will the whole contract be void, and or the illegal part will be valid and illegal part will be void? Answer: it will depend whether the contract is divisible or not. In case the contract is divisible, then the legal part will be valid and illegal part will be void. But if the contract is not divisible, the whole contract will be void, illegal and void. Okay, so see, the law on this point is contained in section 58, which says that in case the alternative promise, one branch which is legal and other illegal, the legal branch alone can be enforced. But if the things are inseparable, indivisible, then the entire agreement is void. See example: A and B agree that A shall pay 1 lakh for which B shall afterwards deliver to A either rice or smuggled drugs. Now beta, this is a valid contract for rice but not for smuggled drugs. That is void. Am I clear with this? No. This is not that. This anyways is done in unit 2. Okay. Now one part is left, only one part. Okay. And which is important, comes in exam. That is appropriation of payments. Let's understand what is this. Up till now everyone understood everything? If yes, give me a thumbs up quickly. Yes, give me a thumbs up quickly. Very good. Okay. Now appropriation of payment. Section 59 to 61. This question is kind of important question, okay, because frequently it has been asked. Now see, let's take some example, okay, on this. Appropriation of payment means distribution of payment. Now pay attention properly. Example: H took a loan from M on 1st January 21 for 1 lakh. Okay, this is first part. Now second, pay attention here, forget this thing now for the time. Harsh again took a loan from M on 1st February 21, 2 lakhs. 1 lakh, 2 lakh. Am I clear with this? Now on 1st March 21, I repaid 80,000 to M. The question is, this 80,000 will be utilized to repay which debt? So there section 59, 60, 61 you have to write an answer. Answer beta, section 59 tells me who has repaid the loan? Debtor. A debtor will tell where to utilize this 80,000. So it will be applied as per the discretion of debtor. Then section 60 comes into picture, which tells sir, if debtor is silent, then the creditor can tell where to apply it. If debtor is silent, 80,000 will be as per the discretion of creditor M. But if both are silent, then beta, it will be first seen, is there any exact amount of debt which I have repaid? So basically tell me, is there 80,000 ka debt? No, there is no 80,000 ka debt. Okay, so forget that. If there is example any 80,000 ka debt, so first that will be paid. But sir, in case there is no exact amount of debt, then first debt will be paid first. 1 lakh wala will be paid first. But sir, example, if more than 1 lakh loan, more than one loan is taken at the same time. Example, on the same day, now comes to the second point. Harsh took one more loan from Mohan on 1st January 21. On the same day, I took two loans, 1 lakh, 3 lakh. A first debt will be paid first, cannot come, obviously, because there are two debts. Then beta, what will happen? Then this 80,000 will be distributed in the ratio of the loan. 80,000 1:3. So So for 1 lakh loan, 20,000 will be utilized, and for 3 lakh loan, 60,000 will be utilized. Am I clear? Understood. Now something very important, understand. If the debtor is silent, so section 60 tells creditor we can utilize this amount. It will be as per the discretion of creditor. Now example, if a creditor had given any loan to the debtor which has been time barred debt. Time barred debt means debtor has not paid and basically creditor has not sued for 3 years. It is time barred. So creditor can still utilize this 80,000 for that time barred debt, for repayment of time barred debt. Creditor has the right. Similarly, section 61 tells ki, sir, if both are sold, first debt will be paid first. Basically, in case there is a debt which is time barred debt, okay, so this 80,000 can be utilized to pay that also. Understood? Understood? Clear? Everyone? Yes? Good. So we have finished unit 4. In that, discharge of contract by performance, by agreement, by impossibility, by operation of law. We have done that. Am I clear? Okay. So all the important topics we have covered. Now, breach of contract. Unit 5. Let's understand what do you mean by breach of contract. But a breach of contract means refuse to perform the contract. Very simple. I would not be performing the contract. That is called as breach of contract. Now, breach is of two types. One is actual breach, one is anticipatory breach. Actual breach means refuse to perform the contract at the time of performance or during performance. Like Mr. A and Mr. B promised to marry, Mr. A and Miss B promised to marry each other. But on the date of marriage, B told me, sorry, I can't marry. Okay, or during the marriage, during the process of marriage, she told, sorry, I can't continue this marriage. So basically, that is actual breach. Anticipatory breach means refuse to perform the contract before the date of performance. Like example, these people were about to marry on 1st January 25, but 30th December 24, before the date of marriage, we told, sorry, I can't marry you. That is anticipatory breach. And this can be expressed as well as implied. Expressed means what? She will tell. Implied means, example, she left the house with someone else. Implied. Now you will get question on anticipatory breach. Now what is this question? See. Example, there is a guy Suresh. Me and him made a contract. That was, he will supply sugar to me. Okay, is the seller, I am the buyer. Contract took place on 9 Jan. But he will supply the sugar to me on which date? 16 December. Okay, price is at the rate ₹50 per kg. Correct? Now what happened on 26 November? This guy told, sorry, I cannot supply sugar because of any reason. Now, okay, there are two questions. There are two options which I have. First option, that I can wait, okay, till 16 December and then he doesn't supply the goods, then I'll sue him. Second option, I can sue him on the date of breach only. So which is more advisable? This is how the question will come. So answer is better, okay. Option second is more advisable. You have to sue on the date of breach. Why? Because, sir, example, after that is in case any disability comes. Example, on 11 December, government issues notification that sugar cannot be supplied by individual. Or Mr. S becomes insolvent. Now, beta, can I sue him for the performance? No. It is more advisable. Okay. So option is B. Advisable that B should be taken. You have to file a suit on the date of breach, because example, government notification came, individuals are prohibited from selling sugar. So obviously the contract becomes void there itself. Now you forfeit your right to file a suit. Clear? Understood? Yeah. Now remedies for breach. Sir, in case I committed a breach of contract against you, so basically you will be facing losses. It is wrong against you. So you should have some remedies against me. So what are the remedies you have against me? First is file a suit for rescission. Rescission means, beta, you can file a suit for cancelling the contract. Matlab, now I do not perform the contract. Like example, you and your girlfriend is there or boyfriend. The other person cheated on you. Now beta, will you continue the relation? Obviously not. Clear? So basically cancel the contract. Yes. Second, you can claim damages. Now damages is important. See. Now understand. With this example we'll take. Suresh told that he'll supply sugar to me. Again, at the rate of rupees 50 per kg. But he told, sorry, I can't supply sugar. Now, obviously he committed a breach, so I can claim damages. Now what are the damages? There are types of damages, different types of damages, okay, which I can claim. First is ordinary damage, ordinary or actual damage. Now what do you mean by ordinary or actual damage? This is the actual loss caused to the party because of breach. This is the calculation of that is done as market price of goods on the date of breach minus contract price of goods. Like example, this is the contract price of goods. On 26 November, he told I can't supply the goods. At that day, beta, okay, the price was 60 rupees per kg. So what is the loss to me, beta? 10 rupees per kg because I have to buy it from someone else. So that 10 rupees per kg I can directly claim from Suresh. In fact, I don't even have to mention it in the contract, beta. It is an inherent right. Generally, what law tells you, if you want to claim damages, you have to mention in the contract. But this is not required. It is a common sense that if you don't supply the rice to me or sugar to me, okay, then I have to purchase it from somewhere else, and at that time the rice rate is higher, so I have to buy it at the higher rate. So basically you can directly file a suit. Am I clear? Okay. Next, special damages. Now what is special damages? Special damages are over and above ordinary damages. These are the damages caused because of special circumstances. Okay, is it an inherent right to claim? No, you can claim it only if it is mentioned in the contract. And one more damage after special damages, it is liquidated damages. What do you mean by liquidated damages? These are the damages if the amount of damage is mentioned in the contract. If you don't perform, you have to pay me this much amount. If the amount is mentioned, it is liquidated. If the amount is not mentioned, then it is unliquidated. So I'll give you an example of liquidated and special damages. Okay. This guy Suresh told me he'll supply me rice at the rate of 50 rupees per kg. Now what I was about to do, I was about to buy the rice from Suresh and I was about to supply it to Vishnu. Now Vishnu and me had a contract where it was written that if Harsh fails to supply the rice to Vishnu, so Harsh has to pay 500 rupees to Vishnu. So between Harsh and Vishnu, beta, is the amount of damages mentioned? Yes. So that is liquidated damages. But beta, question is that I face this loss of 500 rupees because of whom? Suresh. He did not supply the rice to me. Can I recover it from Suresh? Between Harsh and Suresh, this is beta special damages because of special circumstances, and I can recover it only if it is mentioned in the contract. Understood properly? Clear? In your book there is a case. I'll explain that case also. Here, State Hadley versus Baxenden. Now, what is that case? I'll explain it. There is Mr. A. He has a rice mill. In that there is a shaft machine. Shaft machine means beta machine which separates rice and paddy. That got broken. Now he has to send it to B for repairing. But how can he send it, beta? Okay, he appoints a transporter, Mr. C. Transporter. Now understand, the time duration for reaching from point A to point B, place A to place B, is 1 day. Coming back is 1 day. Repairing is 1 day. So total how many days? 3 days. And beta, this machine is not there, so basically he cannot do business. So there is a notional loss of 50,000 rupees per day to A. Okay. Now the total 1.5 lakh is anyways lost. Now A appointed C to send the repair machine to B. One day he went, B repaired in one day, and C was bringing it back. Now while bringing back better, C should have brought it in one day, but C went to his village, stayed there for one day and then came. So basically came after total 4 days. Can I say 50,000 rupees per day extra damages loss was there to A? Question is, can A recover it from C? Answer is yes, but only if he has mentioned that the same in the contract. Because beta C will not get a dream na, that if I per day 50,000 losses he is incurring. So answer is beta if he mentions, this is special damages. If A mentions it to C, boss, you have to come here, take it on time, or else per day I am incurring this much. If you are delaying, then I'll claim that loss from you. Then only he can claim it, or else not. Understood properly? Yes. Next, exemplary, vindictive, punitive damages. Now, what is this? Exemplary, vindictive, punitive damage. Let's understand. Example. So these are the damages beta which are given only in two situations. These are not given for financial loss. These are given for loss of reputation. Okay, and feelings. So only for Indian two cases beta these damages are given as per Indian contract. First, breach of promise to marry and wrongful dishonor of check by bank. If you tell that you will marry someone and basically you did not marry that person, on the day of marriage you are telling I don't want to marry. So basically in India beta marriage is a big institution. If the person doesn't, if I don't marry a person, that person's beta image will be tarnished, reputation will be lost. So for that loss of reputation, that person can sue me. Now it depends upon the reputation. Higher the reputation, higher will be the damages. Am I clear with this thing? Second case, wrongful dishonor of check by bank. Example, I gave a check to Mr. B. Okay, and he deposited the check, and my bank, ICICI bank, I had funds in my account, but then too beta my bank told negligently that funds are not there and dishonored the check. So there is a loss of reputation of mine. Can I sue the bank for loss of reputation? Yes. But okay, here there is inverse relation. Lower the amount of check, higher will be the damages, because lower the amount of check gets dishonored, more reputational loss would be there. So more damages. Am I clear with this thing? Next, nominal damage. What is nominal damage? Sir, in case I committed a breach of contract against you, but there was no financial loss, no reputational loss also, but I committed a breach now. So you can sue me and take nominal namesake damages. Now namesake damages are 10 paisa to 10 rupee. I will be like, sir, 10 paisa to 10 rupee, yeah, why are they mentioning that amount also? They should increase it. Answer is beta, 10 rupees value you should not take as of today. You have to take the value of 10 rupees as of 1872 when the act was made. Understood? That is what the point. Next is deterioration of damages for deterioration of goods during transit. Now we'll take one example. Okay, Mr. A, he has a cow shed. He is a milkman. He has lot of cows. Okay, he milches them. Okay, and sells the milk. One day, Mr. B told that you send me 100 liters of milk. Okay, I'll be waiting and send it to the airport on this day. Example of 30th December. Okay, I'll collect from the airport. Now, Mr. A, what he did now? Mr. A milks the cows. 100 liters of milk are there. How to send it? Okay, he is in Malleshwaram, Bangalore. Okay, and basically he has to send it to the airport. Now Malleshwaram to airport is generally morning time, 1 hour maximum, not more than that. Okay, so what Mr. A did, A appointed a transporter, Mr. C, and told him give the milk to the airport. We hand it in the airport. Mr. B will be there. Now tell me, there is no refrigeration facility. It is quite summer season also. So if you know that if I bring a milk, not the refrigerator one, and I keep it like directly from the dairy I bring, from the cow shed I bring, and I keep it in my kitchen, not in the refrigerator. Maximum beta for two hours it will not be stale. After that it would get stale. Yes, it is like that. 2 hours to 2.5, 2.5, 3 hours maximum. Okay, everyone knows that. Is it a rocket science to understand? No. Mr. C also knows boss milk is there, closed environment, no refrigerator. So he should have directly gone to the airport. He did not go. He first went to Jayanagar, then went to Banarghatta, then went to airport. Okay, and it took 7 hours. By that time, that milk became paneer. Am I clear with this thing? Now, will Mr. B collect it? No. So can I say it is loss or deterioration to the goods during transit? Yes or no? Because of whom, beta? Mr. C. So can Mr. A recover that loss from C? Answer is yes. Is it required to be mentioned in the contract? No. Okay, he can directly claim it. If there is any intentional delay in transit, any loss occurred has to be paid to the aggrieved party. It is an inherent right to claim such damages. Am I clear? But question comes, sir, in case during transit it was not intentional delay. There was an accident which took place, and because of which there was a lot of traffic. Happens sometimes, like yesterday it happened. Yesterday, generally when I go from here to another branch, it takes 25 minutes maximum. Yesterday it took me literally 1 hour 10 minutes. Happens. So sir, because of reasons beyond the control of C, there was lot of traffic and he got delayed by 5-6 hours and the milk is perished. So now beta will he be liable? Answer is generally no, unless otherwise agreed. That is called as indirect damages. Okay? So damages occurred due to circumstances beyond control of party. This is generally not recoverable. Am I clear? Our reputation is calculated. Okay, how come to know, sir? Very simple, but it depends upon his social reputation. Okay, so court will ask some people, interrogate some people, ask some people as witness. Okay, what is his status? What is his status in basically society? And then beta, generally you demand this thing, and then beta judge decides whether to give you that amount or not. Okay. So we studied beta. In case of breach of contract, okay, there are 5 remedies. First one beta we studied, where is it? Suit for rescission. Second, suit for damages. Third is suit for quantum merit. Okay. Now what is suit for quantum merit? In a very simple term, I'll explain you. Quantum merit means what beta? As much as earned. How much you have worked, you can claim payment. Now understand. Example, Mr. A told Mr. B that boss, you manufacture 100 chairs and give it to me. I'll make payment of rupees 1 lakh. Now this was the contract. Guys, B manufactured 50 chairs by the time, supplied it, and still he is going to produce more 50, manufacture more 50. But beta, in between, after receiving 50 chairs, he told I don't want to continue here. Did I commit breach or not? Yes. So who's the aggrieved party? B. Question is, can B claim payment for that 50 chairs? Answer is yes. As much as earned. How much you have worked, you can claim. Now because this is divisible. But example, A told B, it is his house, paint this house. Now he started painting this wall, this wall, this wall. He was continuing the paint. But suddenly Mr. A told, sorry, I don't want to continue the painting job. So can B claim money? Yes. But this is not divisible. So B can claim a reasonable proportionate amount. Okay? So he can claim a reasonable amount. That is quantum merit. But question is, sir, in these cases, beta, B was the aggrieved party. So aggrieved party can claim quantum merit. Yes. But can the party who is committing breach, can he claim quantum merit? Answer is yes, only if the contract is divisible. Like example, here B supplied 50 chairs and A and A still wants more 50 chair, but after supplying 50 chair, B is like, sorry, I can't supply more. So B is committing the breach. Can B beta claim quantum merit? Answer is yes, only if the contract is divisible. Like example, give a very funny example and you will understand it properly. Example, I went for a haircut, okay, and shaved. The person told for haircut 500 rupees, shaving 500 rupees, okay. He did haircut, but shaving he told, sorry sir, it's very late, I can't do it, okay. So you can do it, get it for done from somewhere else. Now beta he committed a breach. But okay, I am the aggrieved party. Question is, but can he claim payment for the haircut? Answer is yes, because it is divisible. But sir, example, I went only for shaving and basically it will 500. He did half shave. He shaved half. Now second half is like, sir, it's very late. You get it done from somewhere else. But sir, give my 250 rupees. Will I give his 250 rupees? Properly I'll give him. Yes or no? Simple. Clear? So basically, if the contract is divisible, then only beta he can claim, or else. Understood? Good. Next, suit for specific performance. Now specific performance I told you in Sale of Goods Act. Do you remember that Mughal period painting and all? Sir, in case I told that generally what happens that in case I commit a breach, I tell you take damages and move on. But many cases where the damages are not an adequate remedy. It's not an adequate remedy. In that cases, beta, okay, what court will tell this person who's committing breach that you have to specifically perform, okay, what you promise. Like example, if I enter into a contract to buy a Mughal Mughal period painting from Mr. X and it is only one painting, he tells yes, okay, I'll give it to you and I give token, and I told next tomorrow I'll come and take it. Next day I came, I'm ready to make payment, but that person is not giving it to me. He's like, no, sorry, I changed my mind. Okay, I'm cancelling the contract. Okay, so you take damages, no problem. Tell me, beta, irrespective of how much damages is giving me, will I get that painting anywhere else? No. So there, beta, TK court will award specific performance. Okay, so see. So basically, party has to perform what he promised in the contract. Courts award specific performance or monetary compensation. It is not adequate remedy. It is as per court's discretion, because there is no section tells you. Section is there which tells you that in this cases better you have to give specific performance. Specific performance decree decision, but it will not be given in this cases. When it will be given, it is as per court's discretion, no law tells. But there are cases where specific performance will not be given, which is mentioned in the law. First, monetary compensation is an adequate remedy. Like it is a normal painting, not Mughal period. You can get that painting somewhere else also. So court will take compensation. Don't cry. Next, performance is based on personal skills. Like example, Noora Fateh told me I'll come and dance, but before the dance, she got her leg fractured. So now, beta, can you tell her to dance? No, she can't dance. It is based on skills. No. If you tell her to dance, rather than beta Dilbar, she'll come. Okay, I'll now perform. Okay, she'll come and she'll be like, she'll sit on the chair and say, Satyam Shivam Sundaram. Okay, will it be okay? No, you can't enforce it. Next, contracts which require continuous monitoring by courts. Let's see, what is this, beta? Courts, like example, I'm the judge, I give specific performance order. So it will be for one shot performance. Like in front of me, beta, the Mughal period painting will be given and I'll sign on that order. Okay, specific performance was done. But if it is a big contract, like building contract, A told B that he'll construct a building, in between he left. Now beta, B wants A to perform the building, he is claiming specific performance. Now as a judge, if I give specific performance, I have to sit every day beneath the building and see the construction. Do I have time that much as a judge? No, obviously not. So specific performance will not be given in that case. Am I clear with this? Understood everyone? Next is injunction. Now what is injunction, beta? It is not injection, it is injunction. Injunction means stay order. This is generally given in cases where beta performance are based on skills. Like example, Noora Fateh told that she will perform Friday night at Christ College and nowhere else. But then she's telling me, sorry, I have a thin line fracture in my leg, I can't perform. So can it be enforced on her? No. But she told us she will not perform anywhere else on that day. Basically, example, she's getting more payments in some other college. She's going Friday night performing there. Will it be okay? No. Not. That can be stopped. Am I clear with this thing? Understood? Clear? This happens many a time. It basically actors take multiple movies at a point of time. So they give dates. On this date, I'll come for shooting for this movie. But if they and it is written on that day, they will not go anywhere else. But the other movie is more important. So they tell here, Arey, I have some fever, I have leg pain, I can't come. But they are going to another movie shooting. And the first movie's director and producer stop them. Yes. Am I clear with this? Okay, that is injection. Clear? So this is where unit 5, breach of contract, comes to an. I hope you understood all the remedies. If yes, give me a thumbs up quickly. Yes. Good. Now, the sixth one, contingent and quasi contract. Now, what is contingent and quasi contract? Let's understand. Beta, contingent contract means what, you know? It is a contract which is dependent upon some contingency. See, conditional contract and contingent contract are different. Conditional contract, conditional contract means it is a contract which is dependent upon a condition, and that condition is within our reach. Like example, I say, you sell me, you deliver the goods to me today. Okay, then after 3 days I'll make payment. So this is conditional. If you give the goods, then only I'll make payment. But this is not contingent contract, because obviously it is within your reach. You will deliver the goods to me. You have the capacity to deliver the goods to me. It is conditional. Okay, but beta, contingent contract means what? Okay, which is not dependent upon, okay, which is dependent upon happening or non-happening of a future uncertain event, but that event is not within my reach, within my control. Like example, insurance contract. I took insurance from insurance company, and they tell, "Ki boss, in case I die, my wife will get 1 crore rupees." Now tell me, my death, my living and death, is it within their reach, within their control? No. Basically, such type of contracts are called as contingent contracts. Am I clear with this? Understood properly? Now see, contracts dependent upon happening or non-happening of future uncertain event. Okay, that is a contingent contract. Okay, I hope you understood. Conditional and contingent are different. Okay, you deliver the goods to me. If the goods are of A quality, then I'll make payment to you. Okay, so that is conditional contract. Okay, because obviously, beta, you are supplying the goods. Okay, you have multiple goods, A quality, B quality. You will supply me A quality. I know that is within your control. Anything which is not within any other party's control, and a contract is dependent upon that, that is called as contingent contract. Understood? Now, there are certain rules of contingent contract. Now, what are the rules of contingent contract? Understand. Contract dependent upon happening of an event shall be void if the event does not happen or becomes impossible. So this is the first rule, sir. If a contract is dependent upon happening of an event, if this event happens, then we'll perform. But if the event doesn't happen or happening of that event becomes impossible, the contract becomes void. Let's take an example. See, I am in Mumbai. I am buyer of cotton. Ketan is in Goa. He is seller of cotton. I ordered some cotton from Ketan or Kushal, and he initiated delivery. I called him, how is did you initiate delivery? He's like, yes. How are you sending it? He's like, ship. I'm like, arey yaar, ship transport. I'm very negative on ship transport. Arey ship transport, arey yaar, generally ship drowns. Okay, I have this feeling ship will drown. So I told, okay, it's fine now. You have initiated delivery. What to do? But Kushal, I'll pay for the cotton only if the ship reaches Mumbai, or else I'll not pay. So can I say the contract between Harsh and Ketan or Kushal, whatever it is? Okay, why I'm writing Kushal? Because I have written in the example Kushal. Okay, it is dependent upon ship reaching Mumbai. If the ship doesn't reach Mumbai, the contract will become void. Same thing happened, but example, the ship drowned. Now, is it possible for the ship to reach Mumbai? No. So the contract between Harsh and Ketan becomes void. Am I clear? Okay. Next, a contract dependent upon non-happening of an event shall be performed only if the event does not happen or the event becomes impossible. It is a contract which is dependent upon non-happening of an event. If the event doesn't happen or happening of that event becomes impossible, then only it will be performed, or else not. See. Beta, this Ketan understood na that boss, I will not pay if the ship doesn't reach Mumbai. So what he does na, he takes insurance of the cotton. The cotton is of 2 crore rupees from AIB insurance company. Now what does AIB insurance company tells? AIB insurance company will pay 2 crore rupees full value of cotton to Ketan if the ship does not reach Mumbai. So this is dependent upon non-happening of an event. Example, ship drowns, then beta AIB company has to pay Ketan 2 crores. But if the ship reaches Mumbai, will it be performed? No. Then basically AIB company is nothing, has to pay nothing to Ketan. Okay. Next, any contract dependent upon future conduct of a person becomes void if the person does not act in the agreed manner. Any contract dependent upon future behavior of a person. If the person doesn't behave in the agreed manner, contract is. Let's take an example. Mukesh Ambani and me, we were about to have a 10,000 crore ka deal contract, but I told sir, this is a big contract and I can deal with you only if we are relatives or very good friends. We are neither, so sorry, I can't do deal. So Mukesh Ambani tells me, "Arey, you want to be relative? No problem. Chalo. Okay, you do one thing. You and Isha Ambani, example, you get married. So now then we'll be relatives. So obviously we can have this contract." I told, I am okay. You should ask Isha Ambani. Now better tell me, this whole contract between me and Mukesh Ambani is dependent upon Isha agreeing to marry me. Isha saw me and she was like, I'll die but I will not get married to you. Okay, and she married Anand Piramal. Now tell me beta, Isha Ambani's and my marriage is possible or impossible? Impossible. So basically now this contract between me and Mukesh Ambani will be void. Am I clear? Understood? Good. Next, contracts contingent upon events which are impossible will be void. Me and you agree to do something, okay, but only if this uncertain event happens, but that even happening of that event becomes impossible, so it is void. Like example, A tells B that he shall pay 1 crore to B if 2 parallel lines meet. Now, is it possible that 2 parallel lines will meet? No, obviously. Basically, the contract becomes. Am I clear? Understood properly? Okay, good. Now, we'll go to quasi contracts, quasi contract. Now, what is the meaning of quasi? Quasi means deemed, assumed contract. Okay, assumed contract. So see, sir, actually, whenever a contract is made, so there are steps, ingredients, offer, acceptance, and all. But in quasi contracts, beta, all these steps will not be there. There is no offer, there is no acceptance. In fact, these are not contracts also actually. These are circumstances. What law tells that if beta these circumstances exist and there are parties who are under these circumstances, it is assumed that they have entered into contract, and accordingly beta the law will give some rights and duties to them. These are deemed contracts. Now why it is made beta? It is made on the principle that no one should benefit himself at the expense of another. So there are 5 sections for quasi contracts, 5 quasi contracts, section 68 to 72. These are 5 circumstances where one party is expending and the other party is getting the benefit. Not as no, it's not possible. person, okay, who is expending should only get the benefit. You one person cannot do masti maza, cannot enjoy at the suffering of another. Okay, so which are these situations? No man should benefit himself at the expense of another. Which are the 5 quasi contracts? Section 68, necessaries supplied to person incompetent to contract. Do you remember we had done necessaries supplied to minor? If I supply necessaries to minor, can I sue him for that? Answer is no. But can I recover it from the minor's estate? Yes. That is the right which I have. Did I had a contract like that with the minor, or if you have a property, I'll sell it and get it? Nothing. But it is my right. Person supplying the necessary has a right to claim the expenses made from the estate of that person to whom necessaries have been supplied. Next, payment by interested person. Now, what is this payment by interested person? This point tells that, sir, if one person makes payment to another, if one person makes payment on behalf of another under a contract where even he is interested, he can claim the payment made for that person from that particular person as such. Now, what is this? See, let me explain. Example, Mr. Harsh is there and Mr. X is there. He owns a godown. I took the godown on rent and stuffed my goods in that godown. Every day I go to the godown, take my goods and sell it. One fine day I went to the godown and I saw better government authorities are putting a seal on that godown. I ran and was like, "Arey boss, because one seal is in, my goods are inside that. We cannot remove the seal. It's a crime." Then beta, I told Gary, "Why are you putting seal?" This government authorities told Mr. X has not paid land tax on this godown since 10 years. We are putting a seal. I told, "Arey, my goods are also that." So they told, "We don't know that. We have to put seal." I called Mr. X, "Bhai, kidhar hai? My goods are there. Please pay, make the payment." He did not receive the call. Then I told government authorities, "How much is the amount?" They told 2 lakhs. I told, "Okay, I'll pay." I paid 2 lakhs. So did I make payment on behalf of X? Why? Under a contract. Why? Because I was interested in that. My goods were there in the godown. Now this particular authority is left. After that, beta, Mr. X called me after 2 hours. So I was sleeping. What happened? I said, "Sir, don't sleep. This situation happened. Give my 2 lakh rupees now." So Mr. X says, "You did it voluntarily." And one thing you do voluntarily is not a consideration only. I am not bound to pay. Is Mr. bound to pay me? Mr. X bound to pay me the amount? Answer is yes. Because it is a payment made by me, okay, in a contract where even I was interested. So it is my right. That's section 69. Next is non-gratuitous act. Sir, if I understand that someone is doing something for me non-gratuitous, gratuitous means voluntary, non-gratuitous means non-voluntary, and I let him do that thing for me, then am I bound to make payment? Yes. Like a coolie picking up a bag for me, I allow him to do that. Basically, am I liable to pay him or not? Okay. One case law is there in your book, State of UP. I'll explain you the case. Shamlal versus State of UP. What happened in this case? There was a guy, okay, he had a government job, okay, and basically, Mr. A, basically there is a government department. They give him a notice that, boss, you have to compulsorily retire now. This is your age, you have to retire. He told, no, I am fit for working. They told, don't work, I'll work. What he did, he filed a petition, the court. I have to work, they are not allowing me to work. Now, the trials case ran for 6 months. Until 6 months, better Mr. A was doing job. So basically, government was paying salary. Example, 1 lakh rupees per month, total 6 lakhs. Now, government is telling, but you don't have to do it. Then he is doing it. Now, court told ki, ha,
your age is as such, okay, it's a clear case, you should not work, you should stop work. So can I say beta here now A was doing the work voluntarily, gratuitously, so now can he keep that 6 lakh? No, he has to pay it back to the government department. Am I clear with this thing? Understood? Clear? So Shamla was directed to return the salary plate. Clear? Because he is doing gratuitously, not non-gratuitously. Next, section 71, finder of goods. This is important, okay? Now see, let's understand. And I'm telling this, but then too people will make mistake. Okay? Sir, example, there was a guy, Dharmik. Okay, he was aside a road, he was standing aside a road. Okay, and suddenly he saw there is a truck of medicines. Okay, it met into an accident. Okay, and basically the driver ran away. Medicines fell out. Nobody is there. So now what Dharmik has to do? Okay, this is the situation. Dharmik has two options. First is like an Indian, just say and go on. Second, he can take possession of the goods. But if he takes possession of goods, he becomes finder of goods. Now, if he becomes finder of goods, there are certain rights and duties assigned on him. First, what is his duty? He has to take proper care of medicine. He cannot throw the medicines. Second, cannot use the medicines. He can't consume the medicines because it is not his medicine. This belongs to Harsh, to me. Make reasonable efforts to find true owner. He has to go to the police station. He can inform. Now, beta, the reason is that, sir, if you don't inform police, it will be as good as you have done robbery. It is goods of mine, and basically without informing authorities, you took it. Basically, you have to make reasonable efforts to find true owner. Now, what are your rights? What is the rights of Dharmik? First, beta, can he retain the goods? Yes, you have a case, Collins versus Howler. What happened in this case? A person received some, he was in the jewelry shop. He received a ring in the jewelry shop which was on the floor. He asked the person, jewelry shop owner, is it your ring? He told no. Now, okay, he went outside, asked people, they are like no. Inside people no. So Mr. A, who found the ring, he gave it to the jewelry shop owner, told me if the owner comes, give it to him. Okay. Now he left for job. Evening he came to the jewelry shop owner and told me, did the owner come? He's like, no. Like, give the ring to me then. Jewelry shop owner told me, it is not your ring. How can I give it to you? No, I am not giving. Can Mr. A claim that ring? Answer is yes. Because finder of goods has the right to return the goods. Understood? Second, can he claim expenses made on goods? Answer is yes. Example, in case of Dharmik, the medicines were there, so he purchased a mini fridge of 2000 rupees to store the medicine, because that medicine had to be stored in cool and dry place. So basically, can he claim it from the owner? Yes. Can Dharmik claim reward from me? I found your medicine, give me reward. Answer is yes, only if I have announced it. If I have not announced it, then better can he claim it? There is no. Next, can he sell the goods? Can Dharmik sell those medicines? Answer, generally no. But yes, if certain combinations of conditions are fulfilled. Now, what are the combination of conditions that have to be fulfilled so as to give Dharmik the right to sell the medicine? First, true owner is not found. I am not found. Or true owner is found but not ready to pay expenses made on the goods. And goods are perishable. Goods are going to be perished. So he can sell. So if true owner is not found and goods are perishable, sell it. True owner is found but not ready to pay expenses and goods are perishable, sell it. But sir, what about durable goods? The same thing. Durable goods you can sell, Dharmik can sell it. Rather than medicines, it is furniture. He can sell it. Okay, if he has expended 2/3 or more of the value of goods on the goods in preserving them and better finding the true owner. For example, the goods are of 100 rupees. An example, he has expended 66.66, that is basically 67 rupees in finding the true owner and basically preserving the goods. Then beta, take he has a right to sell. But what are the other conditions? True owner not found, and basically you have spent 2/3 of the value of the goods. Then sell it. Or true owner found but not ready to pay expenses. Then basically, and finder has expended 2/3. So basically sell. Because it is as good as you have purchased the goods. So 1 plus A sell, 1 plus B sell, 2 plus A sell, 2 plus B sell. So these are the combination of conditions which you have to write in the paper, then only you are going to get marks. Am I clear with this? Understood? Okay. That is finder of goods. Next beta, section 72, goods or money given under mistake or coercion. If anybody has taken money from me, okay, under coercion, okay, I have a right to take it back. Like example, this case, Trikam Das versus Bombay Municipal Corporation. What happened? Mr. A was traveling in a tram. Tram is basically tram is running in Kolkata now also. Okay, it is kind of mini train. It goes in between the roads also. Okay, there are tracks. Now, but now he did not have ticketless. So the TC came and he charged 5 rupees. He told me, if you do not give me 5 rupees ticket, then I will put you in jail. Actually, the fine was only 1 rupees. But in the fear of jail, beta, ticket he paid 5 rupees. So can I say that TC collected beta more money under coercion? Yes. Later on, beta, he understood fine is 1 rupees. So he filed a case to get back the 4 rupees. Is the Bombay Municipal Corporation liable to pay that? Answer is yes, because this tram was run by whom beta? Bombay Municipal Corporation. Am I clear with this? Understood? Clear. So similarly, beta, if sales tax officer versus Kannaya Lal, sales tax officer charge more sales tax by mistake. Okay, so is it required to be paid back? Answer is yes. Am I clear? Like how you get IT return, income tax refund. Understood? So this is section 68, 69, 70, 71, 72. Okay, which are nothing but quasi contracts. I hope you understood everything. Yes or no? If yes, give me a thumbs up. Yes. Okay. So here, okay, our unit 6 also comes to an. Okay. So great. Now we'll be starting with special contracts. But for special contracts, I'll give you 2 to 5 minutes break. Okay. Then we will continue. Okay. Sure. Chalo, guys, let us start with special contracts. Sure. Now, guys, we have finished Indian Contract Act general part. Now we have to do second part, that is special contracts. Now in special contracts, there are four types of contract. First, contract of indemnity, contract of guarantee, contract of bailment and pledge, contract of agency. Four special contracts. One by one, we'll do all the contracts. Okay. Contract of indemnity, there are only two sections, section 124, 125. Now, what is contract of indemnity? Before we understand indemnity, contract of indemnity, we need to understand what do you mean by indemnity. Indemnity means to save from loss or liability or to compensate the loss. If I say I shall indemnify you, that means I am telling I shall save you from loss or liability. Am I clear? But sir, what is contract of indemnity? Contract of indemnity as per section 124, it means a contract where one party promises to save the other party from loss or liability. But why would anyone do this thing, sir? Generally people say, na, I will sue you for my loss. Here you are telling I will save you from the loss. Why would anyone do this? So I'll take an example why people do it. Example, there is A Limited. It has got a contract to build a bridge, construct a bridge. But it gives the contract of constructing the bridge to Mr. B. He is a contractor. Now A Limited tells Mr. B, sir, if the bridge built by you collapses because of structural defects, then I have to pay a lot of money because people will die. I have to pay compensation to government for these people who lost their life, crores of rupees. So how can I give you contract? So Mr. B tells, sir, I trust my construction quality. Then too, sir, I am telling, if the bridge built by me collapses due to structural defect, whatever compensation A Limited, sir, you have to pay, that I will pay. So can I say, madam, Mr. B is saving Sister B is saving A Limited from loss or liability? Yes or no? So here, okay, we can say Mr. B is indemnifying Mr. A, that is A Limited. So here, Mr. B, there are two parties in contract of indemnity. One indemnifier, okay, indemnifier, and one indemnified. Indemnifier is the person who saves the other from loss or liability. Indemnified means the person who is being saved. Am I clear with this? So basically it is a contract where one person promises to save another person from loss or liability. But the second part, this is first part, second part is a bit twisting. Cost due to act of promisor or act of third party. Like example, okay, but when I say contract of indemnity, I have entered into contract of indemnity. That means I promise to save you from loss or liability. I am the promisor, you are the promisee. But that loss or liability should be because of whom? Because of me. Here see, Mr. B tells now, if the bridge built by me collapses, losses should be because of you or because of third party. I'll give you example of third party. So what does that mean, beta? Here, am I telling that I will save you from loss or liability caused because of your act? Act of promise, is it covered? No. If the promisor tells promisee, if you bear a loss because of yourself, I will save you from loss. That might be a valid insurance contract and all. Will it come under indemnity? Like example, when you buy a new car, okay, you take comprehensive insurance. The insurance company tells that if you yourself dash the car, okay, then to better insurance company will make payment. Insurance company's promisor, you are promising. So if there is loss to you because of your act, that is also covered. That is valid insurance contract, but will it come under indemnity? No, because in indemnity, I promise to save you loss from loss or liability caused because of me or because of third party. Act of yours or loss because of you yourself.
I will not be covering. Am I clear with the same? Sir, one act of third party, I'll tell you. Mr. A and Mr. B are playing in their building. Mr. C comes and tells, get out, don't play. Why? Because you are playing here, my bike is parked here. If my bike gets damaged, Mr. A tells, sir, if your bike gets damaged by me, I'll pay the loss, don't worry. Mr. C tells, what about B? You will pay for you. Mr. A tells, okay, if your bike gets damaged by me or my friend B, okay, then I'll make the payment, don't worry. So can I say, beta, Mr. A is promising to compensate or save Mr. C from loss or liability caused by himself or by third party. He is the third party. That is contract of indemnity. Am I clear? I hope everyone is clear with this. Great. Now there is a question. Now I'll not explain it in depth, okay, because it's a crash course. In normal lecture, I explain everything in depth. All insurance contracts are contingent contracts. True or false? All insurance contracts are contingent, na, hai na? All indemnity contracts are contingent. Yes. If the bridge built by me collapses, if your scooty gets damaged, it's dependent upon happening of an event. So basically all insurance contracts are contingent, all indemnity contracts are contingent. So does that make all insurance contract indemnity contract? Answer is no. Okay, so sir, which insurance contracts are valid insurance but not coming under indemnity? See, it is given. Are all insurance contract indemnity contracts? No. But following insurance contracts, that is following insurance contracts are not coming under indemnity. They are valid insurance contracts but not indemnity contract. First is life insurance contract. Sir, why life insurance contract is not there? I'll give you understanding only for this. See, what is the meaning of indemnity? To save from loss or liability, to compensate from the loss. I took insurance from insurance company and it tells that if I die, my wife will get 1 crore. Are they compensating the loss of life? Can anybody better make good the loss of life? No. Which is not fitting into the meaning of indemnity. They are just paying money. What my wife would want, okay, I should die and she should get money. No. He will be like, no, you should not die. I don't want money. Nobody can compensate the loss of life. So it is not indemnity. Next, insurance for loss caused due to act of promise is not covered. Just now we studied. Act of God is not covered. Loss should be because of third party or because of promisor. And insurance for loss due to accident is also not covered. Am I clear? So basically, okay, these are valid insurance contract but doesn't come under the term indemnity. However, better, these following insurance contracts will come under indemnity. These are valid insurance as well as they will come under the purview of indemnity. First, marine insurance and fire insurance. Marine insurance means insurance of the goods which are kept on the ship, which are vessel through ship. Okay, so these are basically valid insurance and they also come under indemnity. Okay, clear? Good. Next, indemnifier cannot sue third parties. See, this is one line which you will get and maybe they will say comment on this. Indemnifier cannot sue third parties unless there is an assignment in his favor. Comment. Now what does this say? Example. Mr. Harsh took an insurance from AIG insurance company for what, you know, for his car. Mr. Harsh purchased a new car, Nano, of 2 lakhs. Okay. Now, I love my car. So I took insurance from a insurance company. And in that insurance it is written, if the car gets stolen, if somebody steals that car, then beta insurance company will pay full value of the car to Harsh. So can I say, beta, insurance company is promising to save me from the loss or liability caused by third party. Some third party will steal the car. Yes or no? It's a valid insurance contract as well as valid indemnity contract. AIG insurance company is the indemnifier. I am the indemnified. Now, Mr. M stole the car. My friend only stole the car. Now, I did not get the car. I searched for the car. Then I went to insurance company. Gave them the proof. They paid me 2 lakhs. Now, after some days, the insurance company found Mr. M. Can they sue Mr. M? Answer is no, because M will be like, who the hell are you? Why are you filing a suit? They're like, we are insurance company. So he'll be like, why? So what? They'll be like, we paid. Okay, you stole Harsher's car, na? We'll sue you. But Harsher should sue me. Who the hell are you? We paid 2 lakhs rupees for that. He'll be like, did I tell you to pay? They can't sue. But example, what insurance company did? They paid me 2 lakhs. So they told me, Harsher, you got the money, now you can buy a new car. Do one thing, transfer the car's ownership to us. I asked why. They told me, Arey sir, in case this car is used by M for illegal purposes or illegal things, then you have to suffer. Haan, yaar, correct. I transferred ownership to them. That is, I assigned the ownership of the car to them. Now can AIG company file a suit on M? Answer is yes. Now see what is the line beta. Indemnifier cannot sue third parties unless there is an assignment of ownership in his favor. Is it correct or not? Okay, good. Okay, I hope you understood section 124 properly. Now section 125, rights of indemnified against indemnifier. Let us understand this point properly. Sir, indemnifier promises to save indemnified from loss or liability. So basically, can I say, beta, it is the right of indemnified to recover some money from indemnifier to recover whatever he is promised. Yes. So sir, what all amounts, beta, indemnified can recover from indemnifier? That is what we are going to study. So see, example, there is one guy, Mr. M, okay, Mr. Madhav, Mr. Vishnu. Now Madhav has two properties, one ancestral property, this one, put it as P1, and he has just recently purchased P2, another property, just for investment. Okay. Now Madhav is very close to, or this property is very close to Madhav's heart, because it is a place where he has been born and brought up. One day Vishnu comes to Madhav and tells, Vishnu is Madhav's cousin. He comes and he tells Madhav that, boss, this property is my property. Madhav is like, how come? But during division of the property, this property is received by my father. Your father, okay, cunningly took this property. I want the property back. Will Madhav give it? No, he told no. So Vishnu filed a case to get that property. Now Madhav also has to appoint a lawyer, file a cross suit, okay, and recover the property. But Madhav doesn't have money. He just purchased property P2. But he doesn't want to leave property 1. So what he does, he decides to sell the property to me, Harsh. Now when he came to me, I'm like, why are you selling? Just now you purchased. So he told me, sir, this is the whole situation. So I told, okay, you want money so that you want yourself to be saved from the actions of Vishnu, whatever case he files. He told, yes. So I told, how much money will be taken? How much money you would like? What is the total cost which you will incur? Like, I don't know, sir. Depends upon what Vishnu does. So I told, okay, we'll do one thing. If you are okay, you sell the property to me, Mr. Madhav, and I'll not pay you one-shot payment, but I will save you from all the actions of Vishnu. Whatever Vishnu takes action against you, in order to save you, what all expenses will be there, I will bear it. Basically, Madhav was like, okay, no problem. So tell me, is it a contract of indemnity between Madhav and Harsh? Answer is yes, because I am promising to save Madhav from all the actions of third party, Vishnu. So here section 125 talks what all amount Madhav can recover from me. First is better cost of suit. Madhav will file a cross suit, appoint lawyer and all. Okay, application fees of court, that I will pay. Second, damages. Like example, Madhav's lawyer lost, and Vishnu is like, he went to the court and told, see, this was a clear case, it was my property, he wasted my time, energy and all. I want damages for that, for loss of time, for loss of mental harassment. Okay, 5 lakh rupees. Court is like, okay, 5 lakh rupees, give it to him. So basic that also I have to pay. Okay, to whom, beta? To Vishnu. Then beta, compromise amount. Now what is compromise amount? Like example, the matter went for 7 years. Now Vishnu is tired fighting the case. Vishnu tells Madhav, do one thing, give me properties of 10 crores, give me 50 lakh rupees, I'll settle the matter. That is compromise. Now beta, this amount also who has to pay? Harsh. But this, for this amount it is written only if agreed by Harsh. For this amount beta, I can say no. The reason is that what I wrote in the contract, I shall save you from all the actions of Vishnu. This is it the action of Vishnu or it is a mutual settlement between both people? Mutual settlement. I did not agree for that. So if I want to pay, then I can pay, or else no. Am I clear with this thing? So one question comes, beta. All the rights of indemnified against indemnifier under section 125 are absolute rights. Answer no, false. It is not absolute rights. First one is absolute, second one is absolute because indemnifier cannot say no to it. Third one, indemnifier can say no to it. So it is not absolute. It is as per the discretion of the indemnifier. Am I clear? If you understood indemnity contract of indemnity, give me a thumbs up quickly. Okay, very good. Now we'll study contract of guarantee. Now what is contract of guarantee? Let's continue. Sir, contract of guarantee is a contract where one person promises to pay money, okay, on the failure of a third person. Okay, on the failure of third person. Now what is this? What is this whole point? Let's understand. Example, one day Mr. Madhav goes to Mr. Deepak and tells, can you give me 1 lakh rupees loan? So Deepak tells me, okay, I'll give you 1 lakh rupees loan, no problem. But what happens now? Understand. I know you'll pay, but in case something happens to you, you don't even have properties which I can sell and recover it. So I'll give you the loan to you, but can you arrange some person who can give guarantee that in case you don't repay the loan, he will repay? So he's like, I have a friend Harsh. So basically Madhav comes to me and tells this whole scenario. So now I tell Deepak, okay, you do one thing, you give loan to Madhav 1 lakh. If he doesn't pay, then I shall pay. And then when Deepak gives loan to Madhav. This whole concept is called as contract of guarantee. Herein there are three parties. One debtor who's taking loan, one creditor who's giving loan, and one person who's giving guarantee if the debtor doesn't pay, I will pay. That is person is called as surety. Now there are three parties and between in a single contract, and in this single contract there are three separate agreements between three parties. So it is called as tripartite agreement. Now sir, which three agreements? See, first agreement one between Madhav and Deepak, debtor creditor. Second, agreement 2 between surety and creditor, that he will pay if the debtor doesn't pay. And one implied agreement, even if you have not agreed, implied agreement. That example, if Madhav doesn't pay to debtor, okay, to Deepak, then who will pay? Beta Harsh. And in case I pay, can I recover that amount from beta Madhav? Yes. So Madhav shall indemnify me, Harsh, for all the expenses which Harsh has made because on account of default of Madhav. Am I clear with this thing? So this is called as contract of guarantee. Clear everyone? Yes. Okay. That is section 126. Very important section. Now, beta 127 section number 128 is important. 127 is very normal section. Okay. What is 127 tells? Sir, whatever loan Deepak gave to Madhav on the surety guarantee of Harsh is a consideration for Harsh on behalf of from whom beta? From Deepak. Whatever loan creditor or benefit creditor gives to debtor on the guarantee of surety is a consideration for surety from whom beta? From the creditor. That is 127. Now 128. I think this is important section. All these sections are important. Pay attention. Surety's liability is coextensive to that of debtor. As per section 128, the liability of surety is coextensive to that of debtor. Sir, what do you mean by coextensive?
Coextensive means as good as. What do you mean by coextensive? As good as. So see, tell me, liability of debtor is primary or secondary? Primary to the creditor. Liability of surety is primary or secondary? Answer is secondary. But can I say liability of surety is secondary until debtor pays? Yes or no? Okay, if the debtor pays, okay, well and good, okay, then surety doesn't have to pay. If debtor doesn't pay, then surety has to pay. So until debtor pays, okay, no problem, his liability is secondary. But in case debtor failed, so what did the surety tell? In case my debtor fails, I will come forward and pay. So example, debtor failed, beta, then who has to pay? Surety. Now beta, surety's liability is primary, yes or no? Debtor's liability is also primary, surety's liability is also primary. So can you say surety is as good as debtor for the creditor? And yes, and that's the reason now the creditor has a right not to claim payment, not to sue the debtor for the payment, but directly claim payment from surety. Sir, why, sir? I'll tell you logic. See, if you are the creditor, will you do time pass against a person who does not have money? Example, when a debtor doesn't have money, will you waste your money, energy, time, resource against that person? No. Or you will claim the payment from the person who has the payment, has money. Answer is yes, you take it from surety. Because surety only told, if he doesn't pay, I'll pay. So that's the reason if debtor doesn't pay, creditor may not file a suit on debtor, but directly claim the payment from surety unless otherwise agreed. If it is agreed that boss, first you have to sue debtor, recover as much possible, then you have to come to surety, then that will apply. But nothing is there. Basically, creditor can directly claim payment from surety. Am I clear? So see, in case a debtor defaults, the liability of surety is as good as that of debtor. Surety's liability is secondary until debtor defaults on such default. On such default, surety's liability becomes primary. Creditors have a right to sue the debtors, not to sue the debtors, but claim the debt from surety directly unless otherwise agreed. Clear? Everyone? Good. Now, kinds of guarantee. Okay, we understood section 126, 128. Now, if you want to understand contract of guarantee, you need to understand this properly. There are two types of guarantee given. How many types? Two types. First is specific guarantee and one is continuing guarantee. What do you mean by specific guarantee? Specific guarantee means guarantee given only for one transaction. Like in my example, I give guarantee only for one loan. Okay, to whom? Better to Deepak for that 1 lakh. Okay, but the best point of specific guarantee, or you can say the worst point, specific guarantee cannot be revoked. Like example, if Deepak claimed payment from Madhav and Madhav did not pay, Deepak comes to me. Now, beta, listening to that only, beta, I got unconscious and I died. Now, beta, just because I died, beta, okay, will the contract of guarantee come to an end? No. Deepak can, beta, okay, sell my properties and recover that money. Am I clear with this thing? Understood? That right he has. Next, continuing guarantee. Continuing guarantee means guarantee for more than one transaction, more than one loan. Example, we'll take an example for that. See. Example, I told Deepak that Madhav is going to take multiple loans. You give the loans, okay? If he doesn't pay, I will pay it. So it is a guarantee for more than one transaction. That is called as continuing guarantee. Correct? But beta, sir, can continuing guarantee be revoked? Answer is yes. Continuing guarantee can be revoked. Now, how can a continuing guarantee be revoked? There are three methods. First is beta section 130 by notice to creditor. Like example, Madhav had taken already 3 loans and it was a lot of amount. Now I'm like, I don't want to give guarantee here. I just told him now he's taking every next day he's going and taking loans. So basically Harsh told Deepak that boss, from now I am no more a guarantor. So basically my continuing guarantee will be cancelled. But for the future loans, for these 3 loans, but I'll still be liable.
Next, by death of surety, father took 3 loans. After that, beta, due to some untoward reasons, I died. Now, beta, for the future loans, beta, my property will not be liable. But for the past loans, beta, my property will be liable. So basically, by death of surety and by notice to creditor under section 131 and 130, okay, the continuing guarantee gets revoked as regards future transactions. Am I clear with this? Not for the past transactions. Section 62, yesterday only we studied novation. Basically cancellation of old contract and making new contract. If me, Madhav and Deepak cancel old contract of guarantees and make a new contract, changing the terms and all. So basically that is novation. So basically old contract will be discharged, new contract will come into force. Am I clear with this? Yes? Good. Now, understand this thing. This is interesting. Okay, see, pay attention. Sir, debtor and creditor both know that in case debtor doesn't pay, who has to pay? Surety. They both know. So, is there a possibility that debtor and creditor will shake hands with each other and might do fraud with the surety? Yes. That is the reason, beta, law has made 4 sections. In these 4 sections, what is written, beta? In case, in any of the 4 sections, 133, 134, 135, 139, if a surety comes under any of the 4 sections, then he'll be discharged from liability, he'll not be liable to the creditor. Now, what are these 4 sections? See. First, by variation in terms of contract without consent of surety. Tell me, is the surety party to the contract? Yes. In case debtor and creditor make changes in terms of contract, should they inform surety? Yes, obviously. If they don't inform, then surety will be discharged. Okay. Like example, A took a loan from B, debtor, creditor. C was the surety. Interest was 10%. Now they both decided and changed the interest from 10 to 11% without telling me. I'm C. Okay. So basically, will I be there in the contract or I'll be discharged? Answer is discharged, because there is variation in contract without my consent. Sir, but agar with this 10 ka 9% happens, then will I be discharged? No. But because beta, it is in favor, no. I was anyways liable for 10%. Okay. Okay, now anyways I'll be liable for 9%. So it is, if it is against me, I'll be discharged. But if it is in favor, I'll not be discharged. Am I clear? Next. Now here, ICA will try to fool you guys. So pay proper attention here. Pay proper attention. If creditor expressly discharges the debtor, what is written, beta? If creditor expressly discharges the debtor, the surety is also discharged. If the question comes, the creditor expressly discharged the debtor, creditor told the debtor, you don't pay, you po. Hello, then who will pay? Surety will pay. Should the surety pay? When surety understands the fact, he'll be like, the debtor took loan and you are telling you don't pay, you po. So why should I pay? I am also paying. Am I clear? So he'll not be liable. That is section 134. But if the question uses these words, beta, this is non-discharge of surety. I am teaching in discharge part only, so that you can get direct connection. However, if the creditor does not sue the debtor, he did not sue the debtor, does not sue the debtor, or if the word tells creditor omits to sue the debtor, fails to sue the debtor, or creditor forbears, chooses not, omits, that is forbears is omits. So if it is written the creditor chose not to sue the debtor, he did not sue the debtor or omits to sue the debtor, then will the surety be discharged? Answer is no. You remember section 128, I told, okay, surety is as good as debtor for the creditor. If the debtor doesn't have any money, will the creditor waste his time against the debtor, or he'll directly take payment from surety? Directly take payment from surety. Did he tell in this situation, did he tell the debtor, you don't pay, I forgive you? No. He just chose not to sue him. So if the creditor, it is written creditor expressly discharged the debtor, agreed with the debtor not to sue him, so surety will be discharged. But if the creditor chose not to sue the debtor, then surety will not be discharged, surety is still liable. Connection is section 128. Am I clear? Understood? Sure. Now, section 135. If creditor gives additional time for repayment to debtor, okay, without consent of surety, surety is discharged. Like A took loan from B for 5 years. C was the surety. Now it's been 4th year, okay, and A is telling B, hey, can you give me extension of time? I can't pay after 5 years, but I'll pay after 7 years. So B is like, okay. So B directly dealt with the creditor, sorry, debtor. The creditor directly deals with the debtor and gives him extension of time without consent of surety. Is it an kind of variation or not? Yes. So surety should be informed. If you don't inform surety, after 5 years, surety will be discharged. Surety will not be liable to pay a single rupee to creditor after 5 years because you extended that 5 years to 7 years without consent of surety. Now it is also kind of variation, but understand beta, only for this extension of time beta section 135 is done, made. Any other kind of variation apart from this, it will go in 133. Okay. So what does section 135 does? If the creditor directly deals with the debtor, okay, and gives extension of time without consent of surety, there is a variation of contract between debtor, credit and surety. The surety will be discharged. Now beta, section 139. What is written? If creditor fails to do his duty towards surety, if creditor fails to do his duty towards surety, such surety is discharged. Sir, we did not understand. I'll give example. Section 139. Mr. Nayan is a big businessman. He has lot of properties in India, especially in Mumbai. And basically he has that much property that crores of rupees rent comes every day. That much property he has. But some payment comes in online method, some you have to go and collect. But do you think Nayan will go and collect? No. So what Nayan does now, Nayan wants a very honest person who will collect rents for him. So he calls me, Harshendra, I am the most honest guy. And he tells me, sir, will you collect rent for me, salary, whatever you tell. I told, sorry yaar, I am working with Reliance now. I can't work for you. But yes, you want a honest guy, na? So I have my brother, Mr. Akshay. He's an honest guy, you appoint him, he'll collect rent. So Nayan tells me, sir, I trust you, I don't trust Akshay. Can you do the job? I told, Arey, give job to him, beta. He is also very honest guy. So Nayan was like, Arey sir, but I doubt. You know what you doubt? He will run with the money. Okay, chalo, I tell you. I tell Nayan that if Akshay frauds with cash, he embezzles cash, he runs away with cash, whatever loss you will bear, okay, that I will bear for you. So now is it okay? Now he's like, now it is okay. So see, I am surety. N is in the place of creditor and A is the place of debtor. So this is a guarantee given on the behavior of a person. This is called as fidelity guarantee. What do we call fidelity guarantee? Now, but I am also smart. What I told now, in this contract, I gave a condition that boss N, okay, you have to come, Nayan, you have to come and collect cash, whatever cash every day, crores of rupees Akshay is collecting on your behalf. Once in 3 months, you have to come and collect the cash from him. He told, okay, no problem. So that is the duty of surety. Because if it comes after 10 years, will I pay? Some money will go here and there. Might be possible. Now he came, second quarter he came, third quarter he came. After that for 2 years he did not come. Did he commit his breach? He did not do his duty. Okay, this guy vanished with the money. Now Nayan wants to sue me for the money. Will I be liable? Answer is no. Because if creditor fails to do his duty towards surety, then the surety will be discharged. Understood properly? Okay. Now, non-discharge of surety. So we studied better circumstances where surety will be discharged, 133, 134, 135, 139. Now which are the cases where surety will not be discharged? It will not be discharged. There are three sections: 136, 137, 138. 136, 137, 138. Now 137 is already done. Okay, first I'll tell you 138. 138 is very simple. Just now we did better joint promisors and promisees. Same thing. If creditor releases one co-surety, co-sureties are jointly and severally liable to surety, or to creditor. Co-surety means if there are more than one surety. If creditor releases one co-surety, such co-surety is liable for his proportion to the other co-surety or sureties. Let's understand what is this. Mr. Rahul takes a loan from Mr. Akash, and there are two sureties, Ishwar and basically Harsh. Now Akash is my student, but he doesn't know I am that Harsh. Now this guy fails. Now when Akash comes to claim payment from me and him, take a 50,000 I'll pay, 50,000 he'll pay. Akash tell, "Arey Harsh sir, you are to my professor, because of you only I became CA. How can I take payment from you? I'm discharging you." He discharged me, he released me. Now who has to pay entire amount? Okay, Ishwar. So Ishwar pays 1 lakh rupees. But am I liable to pay 50,000 to Ishwar? Answer is yes. So what is this point, beta? E must pay 1 lakh to A, but can recover 50% from Harsh. Understood? So I'll be discharged towards the creditor, but I'll not be discharged towards the other co-surety. Okay. Now what is section 136C? If debtor gets additional time to repay, due to third party transaction, then beta surety is not discharged. Let's understand. See, in 135, what did we study, sir? If creditor directly deals with debtor and gives him extension of time, then beta there is a variation of contract between debtor, creditor and surety. So surety will be discharged. But here what happens? Example, there is a person, Mr. A. He is the project owner, a good project, example, construction of a big gated community he is doing. He is a builder, project owner. He appoints Mr. B as a contractor to construct the building. Mr. C is the raw material supplier to the contractor. Okay, Mr. D is a surety. Okay, to C. Like Mr. B is there. He takes raw material on credit from Mr. C, and basically Mr. D is the surety. He tells you give raw material to him, if he doesn't pay, I will pay. Am I clear with this? Now, what is the point? They have a contract that once the project is completed, within 2 months, Mr. B will pay for the raw material. Okay. Now, one day what happens? Mr. C is Mr. A's friend. So Mr. C and A have a talk, and A is telling ki, "Arey yaar, I was thinking ki this flats will be sold easily, but it is not that easy now. So I'm not able to pay the contractor. So I think he will be delaying your payment." Mr. C told ki, "Okay, I understand." Mr. C agrees with Mr. A that Mr. D has to pay, Mr. B has to pay within what time? 2 months from the project getting completed. But rather than 2 months, I'll give him 6 months credit period, no problem. So can I say, beta, Mr. B, okay, the debtor is getting extension of time from Mr. creditor, from Mr. C, but directly did Mr. C agree with Mr. B? No. Mr. C, beta, agreed with third party. He entered into third party contract with Mr. A and told ki, "Arey sir, okay, I understand. I'll give not 2 months, but I'll give him 6 months to make payment." Basically, is there any variation in contract between B, C and D? No. There will be variation if beta C directly deals with B. He did not deal with B. He dealt with A. Am I clear? That's the reason. Now, will Mr. D be discharged? Answer is no. Mr. D will still be liable for 6 months. Am I clear? Understood properly? Okay, that is the point. Okay, so clear? 136, 137, 138. Did you understand 135 and 136 difference? If 135 does, if creditor directly deals with debtor and gives extension, surety is discharged. But 136 K, if creditor deals with third party and because of third party transaction, debtor indirectly get extension of time, then better surety is not discharged. Okay, everyone, if you understood this point, okay, give me a thumbs up. Great, good. Now, what is the next point? See, up till now we studied better. Here surety will be liable, here it will be discharge, and a discharge, non-discharge. We are just talking about his liability. But sir, we did not study about his rights now. See how selfish we are. We should study about his rights now. He is a party to contract. And as he is taking liability, okay, he has secondary liability, but he is taking liability. Should we give him rights or not? Yes. So basically, surety will also have rights. Against whom better? Surety will have rights against the other two parties to the contract. Who are this? Debtor and creditor. What are the rights of surety against debtor and creditor? Okay, that I am teaching you. The main rights I am telling you. Okay. First, beta, against debtor, surety has two rights. First is right of subrogation and right of indemnification. Section 140 and 145. Actually, indemnification is a smaller right, subrogation is a bigger right. First you get subrogation only, and if you get subrogation, indemnification is not required. Okay, if you get a bigger right, will you go for a smaller right? No. Like if you get Nora, will you go for Dora? No. So see, what is indemnification? Indemnification means something which we have already done. Do you remember I told contract of guarantee is a tripartite agreement. So there are three agreements between three parties. Third agreement was an implied agreement between debtor and surety. That if surety makes payment on behalf of debtor on the failure of debtor, so it is the right of the surety to recover all the amount which he expended on behalf of debtor. So basically, beta, this is the right of surety, which tells that boss, the debtor shall indemnify, reimburse, indemnify surety for all the expenses made by surety because of debtor's default. Am I clear with this thing? So it is the duty of the debtor to indemnify surety for all the expenses incurred by surety due to default of debtor. So here one example, one question was there. A took loan of 100 rupees from B. C was the surety. A failed. So C entered into litigation with B. Okay, as B claimed amount from C, and B and C entered into litigation. Litigation expenses were 10 rupees which was incurred by C. But C lost the matter and ultimately he had to pay B. He paid B 100 rupees. Now how much money beta C can claim from A? 100 rupees or 110 rupees? Answer is 110. Because beta debtor will be liable to indemnify surety for all the expenses. Right? Am I clear? So that 10 rupees also he incurred, C incurred because of failure of A. If A had made a payment, beta will C incur that 10 rupees? No. Okay. Next is subrogation. Now what do you mean by subrogation? But a subrogation means to come into the position of another. To come into the position of another. That is called subrogation. Now see how it is a bigger right here. Example, Mr. Zakir took a loan from Harsh, 10 lakhs. And Mr. Madhav was the surety. Madhav, Mukesh Ambani, Mukhya was the surety. Why should I always be the surety? Okay. Now Zakir fails. So who will make payment beta? Mukhya. Mukhya pays 10 lakh rupees to me. Now tell me beta, I received my 10 lakh, yes or no? So is there any use of me being there? No, I got my right. So in I will go and in my place beta Zakir will come. Sorry, in my case Mukhya will come. Okay. Now, so basically now initially who was the creditor for Zakir? I was the creditor. Now who will come in the position of creditor? Mukhya. Now Mukhya will be the creditor of Zakir. And now Mukhya will have all the rights which I had against Zakir. Like right to sell the property, right to sue him, everything. Am I clear? So this is subrogation. He gets rights of creditor. So why will he go for indemnification? Am I clear with this? M gets all the rights which H had. against Z. Am I clear with this thing? That is called as subrogation, section 140. This is 145. So sir, what are the rights of surety against creditor? See here, section 141. If creditor affects the rights of surety, creditor affects rights of surety, such surety gets proportionately discharged. Such surety gets proportionately discharged. Sir, what is this? I didn't understand. I'll explain. Don't worry. See. There is a guy, Yuzvendra Chahal, and there is one guy, Crash Iyer. Okay. One day, Iyer goes to Chahal and tells Chahal, sir, can you give me loan of 1 crore? Chahal tells, you want a loan of 1 crore? I will give you a loan of 1 crore, but what security you will give? So he gave a security of, like, Iyer had invested in some shares. So he gave that 1 crore ka share as security, that if I don't pay, you sell this. But Chahal told, Arey yaar, I may look like fool, but I am not. The share price goes up and down, round and round. ऐसा share price ऊपर नीचे होता रहता है. So basically, in case your if security goes, shares go down, then what is the use? Okay, no problem, I'll give you loan, but one condition is that I want a guarantor who can say that if you don't repay the loan, he will repay along with the security. So there came a lady called as Dhanashri. She told Chahal that, boss, in case Iyer doesn't pay, I will repay. Chahal is like, okay. Now loan was given. After few months, maybe because of some untoward reasons, example, Chahal sells these shares of 30 lakhs. Chahal shares have shares of 30 lakhs. Now my question is, Chahal sold shares of 30 lakhs. Chahal sold Iyer's shares of 30 lakhs. By doing that, did he affect the rights of Dhanashri? Chahal sold Iyer shares. Did he affect the rights of Dhanashri? Yes. The reason is that subrogation. Example, Iyer did not pay the money and Dhanashri paid the money to Chahal. So Dhanashri will come in the position of Chahal. Now she should have all the rights which Chahal had against Iyer. One of the right was what, beta? To hold security of how much? 1 crore. But now she'll get security of how much, beta? Only 30 lakhs. Sorry, only 70 lakhs. Is her right being affected or not? Yes. That's the reason. Now Dhanashri will also be discharged for the value of 30 lakhs. Am I clear? Now it doesn't matter, guys. It doesn't matter whether Dhanashri knew there was security or not. This right she will have. Okay. The next right to claim set off. Now what is this? Let's understand. For example, A took loan of 1 lakh rupees from B and C was the surety. Now A failed. Who has to pay 1 lakh? Surety. But beta, surety also understood that on account of another contract, A also had supplied goods of 40,000 to B, which B will make payment after 6 months. So ultimately, what is that net debt, beta? 60 only. So C can plead to the court that please tell, see, anyways, beta, B is also the debtor for 40,000. So please give me a set off of 40,000 and I should pay only 60. To whom, beta? B. So basically, this is set off. Did you understand? So can A plead that? Answer is yes. It is on the court to give it or not. But it is his right to claim that. Am I clear with this? To plead that. Okay. Boss sir, if I pay 1 lakh rupees, okay, and then beta B will pay A 40,000, so it is my loss only. Okay. Then I have to go for indemnification, subrogation. So rather than that, okay, we will set up this 40,000 debt and let me pay only 60,000. Am I clear? So that he can do. Next is right to share reduction. Now what is this right to share reduction? See, A took a loan from B, 1 lakh, and C is the surety. Now A failed to pay because he became insolvent and he had a property only of 20,000. Now what happens? C will pay 1 lakh rupees to B. Then beta C will claim indemnification, take over the property, or subrogation, sorry, take over the property of 20. So basically what C can do, he can plead the court, he tell Mr. B to take this property of 20,000 and then I will be liable only for 80,000. Give me that reduction of 20,000. Okay, because I don't have money. Now it is on the court to give it or not. Court will see the financial position of C and may give this right or may not. Am I clear? So this is the right of surety against debtor and creditor. Am I clear? Everyone? Okay. So these are the main sections which I completed. There are 142, 143, 144, 146, 147. Chotu simple section that just go through, read it. Am I clear with this thing? Okay. I hope you understood this part. We have finished better contract of indemnity, contract of guarantee. Okay. Now we will do contract of bailment. I'll tell you the definition only first, then I'll give you 5 minutes break. Okay, then we will go ahead. Sir, what is contract of bailment? Guys, this is not bail, jail wala bail. That is under Indian Penal Code. Now, what is contract of bailment? See, it is a contract where there is transfer of possession of goods, not ownership. Ownership to Sale of Goods Act will come. It is a contract where there is transfer of possession of goods from one person to another for a specific period or purpose, with the condition that after the completion of the period or purpose, the goods shall be returned to the owner. I'll explain you. See, example, renting a car on hire. Or I take a car on hire, rent from Zoom car company for 1 day. So tell me, beta, is there a transfer of possession of that car from Zoom car company to me for a particular period, 1 day, with the condition that after the completion of the period, I have to give back the car to Zoom car or to anyone which whom they say? That is called as contract of bailment. Now, very important, beta, for bailment there should be transfer of possession. Transfer of possession means transfer of control on the goods. Indirectly, you can give possession. If you are giving possession, indirectly you are giving delivery. Now, beta, in bailment also there should be delivery of goods. That is transfer of possession of goods. Okay, and delivery can be of 3 methods: actual, symbolic, and constructive, which we studied in Sale of Goods Act. Correct? Now, understand. So, what we think, I told you, na, if I give this and you hold it, so basically that is transfer of possession. Okay, answer is no. Just because of having physicality of the goods in your hand, that doesn't mean whether there is transfer of possession. In transfer of possession, there should be transfer of control. There is one more concept called as transfer of custody. In transfer of custody, beta, there is no transfer of control. Maybe you have physically the goods, but you do not have control of the goods. I'll give you an example. If I keep my gold in the bank locker, is it bailment? Answer is no. See, why? Because see, the bank will have physicality of the gold, but when I keep the money gold in bank locker, there are 2 keys. One is with me, one is with the banker. Without my presence, can the banker even touch the gold? Answer is no. Basically, physically gold with is them, but basically, do they have control? Answer is no. Am I clear with this thing? So that is transfer of custody, not transfer of possession. So there is no bailment. Am I clear? Understood properly? Clear? Everyone? Okay. Then beta, if I park my car in a parking lot, okay, and basically, okay, lock my car and the car keys are with me, is it bailment? No, because beta, the control of the car is still with me. But if I hand over the keys to them, then is it bailment? Yes. Okay, that is the point. Bailment, in bailment there should be transfer of possession. That means delivery of goods, which can be actual, symbolic, constructive. Transfer of possession means transfer of control. If there is transfer of custody only, that is no transfer of control. Physically the goods are there with you, but it is not bailment. Example, depositing gold in bank locker. Understood everyone? Clear? If you understood, give me a thumbs up quickly. This part. Okay. So now I'll give you two minutes break, only 2 minutes break. Then we'll come and we'll study rights and duties of bailer and bailee, which is very important, comes in exam. Okay, only 2 minutes break. Okay guys, let's continue. Now you understood what is bailment. Now there are certain important things we need to understand in bailment. Okay, beta, do you remember we studied beta no consideration, no contract exceptions. In that one last point was bailment. We did not do it, and I told you we will do it in bailment part. There is separate unit for bailment. So why did bailment come there? Sir, you gave an example, renting a car on hire. So there, so sir, mutual consideration is there. But no consideration, no contract exception doesn't have mutual consideration. So why did bailment come there? Understand. There are two types of bailment. One is gratuitous and one is non-gratuitous bailment. Gratuitous and non-gratuitous. Now what do you mean by gratuitous bailment? Understand. Gratuitous bailment means voluntary bailment. What is gratuitous? Voluntary. Here, one person transfers possession of goods to another. Okay? And one person gives goods to another, okay, but does not charge anything. That is gratuitous. No money consideration is involved. Sir, why would anyone do that? I'll tell you the reason also. Mutual consideration does not exist. But non-gratuitous means here mutual consideration exists. Gratuitous bailment comes under section 25. Non-gratuitous doesn't come. Here mutual consideration exists. I give you something, I'll charge. Like renting a car on hire. But sir, in gratuitous bailment, mutual consideration does not exist. Then too it's a contract. Sir, why? See, the purpose of gratuitous bailment can be either of this. Gratuitous bailment is either done for the benefit of bailer or it is either done for the benefit of bailee. Let's take an example. Example, me and Suresh, we stay in the same building and I bailed my dog to him. Bailed means what happened? Yeah, I got a call from JK sir. I have to fly to Mumbai for lectures urgently for 10 days. Yeah, I can fly to Mumbai for lectures, but problem is that in my house there is a dog, big dog, Great Dane. So who will take care of that dog for 10 days? So I asked Suresh, can you take care of my dog for 10 days? I'll give my dog to you for 10 days. So he's like, huh sir, no problem. Okay, because they generally play with each other and all. So basically now dogs come under the word goods, livestock are included in goods. So there was transfer of possession of goods from Harsh to Suresh. Did he charge anything? No, nothing. Did I charge anything? No. But it is gratuitous bailment for the benefit of whom beta? For the benefit of bailer, for Harsh. Second, for benefit of bailee. Example I gave, I was reading a book. Suresh came and is like, sir, which book you are reading? I told, see, a foundation book. He saw the book and he said, sir, it's such a good book. Can I take it for 10 days? I'll read it and give it back to you. I told, okay. So did I charge anything? No. But is that transfer of possession? Yes. But for benefit of whom beta? Bailee. Am I clear? So sir, why is it a contract? This is a contract in order to put a duty on the bailee that the bailee should not misuse the goods. If the bailee misuses the goods, then beta, take any loss to my goods, can I claim it from Suresh? Yes, under Indian Contract Act. Understood? Okay. So, now, sir, let's talk about non-gratuitous bailment. Sir, can non-gratuitous bailment goods, okay, for which non-gratuitous bailment is done, can it be pre-terminated? Answer is no. Like I took a car from you for 5 days. I paid rent of 5 days. After 3 days, you tell I want the car back urgently. Will I give you the car? No, I'm not bound to give it. Pre-termination is not possible. But sir, gratuitous bailment, can it be pre-terminated? Answer is yes. Now, what is this? Yes, but there is one but. Example, this is me and this is Mr. X, my friend. What happened? Mr. X, he is into the business of being a guide. One day he found some foreigners who came to Bangalore, okay, to explore Bangalore. But what was the thing, no? They came in India for a project to explore India, and Bangalore is left, and they wanted a guy. So basically, Mr. X told, I'll be the guide for you. But problem was there, na, their visa is left only for 5 days. So they told me, see, you help us explore Bangalore, okay, in 5 days, will pay. But in case in between, if you leave, we have to renew the visa, and visa renewal charges X has to pay. It told okay. He made a contract. Now he told, from tomorrow we'll start doing the exploration. Now beta, but for exploring Bangalore, he needs a car na, to help them being a guide. But he did not get a car. I'm his friend. He came to me and he told the whole story. I told, do one thing, na, take my car for 5 days. He said, Arey, thank you. How much money? I told, what money, Ray? It is there at home only. Take it. Anyways, I don't use the car. Okay, as says, I'm on leave. So he told, sure. Bola, हाँ, sure. ठीक है. So basically, I gave the car. It is gratuitous bailment. Yes or no? Now what happened? After 3 days, okay, I told my wife had a holiday. Third day, my wife had a holiday, and she is like, Arey, let's go for shopping. Arey, we can't go because car is not there. Bola, why? Because I gave it to X. Bola, oh, you gave it to X? Very good. I want the car today itself, or else be with X. Okay, X means Mr. X. Okay. So I called him, and I told him, I want the car. He's like, Arey, I told you na, I'll come after 5 days. No, I want the car immediately. He's like, how can you do it? I can do it. I did not charge you. I want the car back. Now what happened? Third day, I took the car back. I did pre-termination. Now I can do this. But what happened? In these 3 days, na, Mr. X earned 60,000 from the foreigners. They paid him 60. But beta, because I pre-terminated, okay, now they have to extend the visa, and that visa renewal charges X has to pay. What was the visa renewal charges? 1 lakh. So see, because of me, how much he earned? 60. Because of me, how much he lost? 1 lakh. What is the net loss? 40,000. So I can pre-terminate. Third day I can take back the car, but I have to pay 40,000 to Mr. X. That is section 159. Am I clear? Understood? I hope I'm clear with this thing. Good. Now beta, we'll be studying rights and duties of bailer and bailee. What we'll be studying beta? Rights and duties of bailer and bailee. And this one question will come from rights and duties of bailer and bailee. Okay, one question, 100% it will come. Now let's understand. But one good thing is there, what is the best thing in bailer and bailee? That, sir, if I study duties of bailer, it becomes rights of bailee. And if I study rights of bailer, it becomes duties of bailee. Okay, vice versa it happens. Okay. So basically, let's first understand duties of bailer, and then we'll study rights of bailer, then duties of bailee, rights of bailee. Okay. First beta, duties of bailer, section 150. Okay. Duty to disclose faults in the goods. Like Mr. A bailed a car to Mr. B, but the brakes were not working. Should Mr. A tell Mr. B about that or not? If the car's brakes are not working properly. Yes. If he does not mention any loss to B, it is a duty of A to pay that to B. But question is, sir, in case A only did not know that boss, the brakes are not working, then will Mr. A be liable? Now it depends upon which type of bailment it was. If it was non-gratuitous bailment, okay, like Mr. A gave the car on rent, so Mr. A will be liable for known plus unknown faults, both. But in case it was gratuitous bailment, like Mr. B told, can I have just one round of your car? You're like, okay, take it. Here, if the brakes were not working, and Mr. A knew about the fact, so will he be liable? Yes. So he'll be liable for known fault or unknown fault beta. He'll be liable for known faults. But beta,
if he did not know about the brakes issue and basically gave the car, will he be liable? Answer is no. In case it is non-gratuitous bailment, he'll be liable for known as well as unknown fault. But if it is gratuitous bailment, then he'll be liable only for known faults. Clear, everyone? Understood? Good. Next, duty to pay necessary expenses. Now understand. Example, Mr. A bailed a horse to B. Now, example, it is first case, sir, on this horse there are some expenses. There are two types of expenses. One is ordinary expense, one is extraordinary expense. Ordinary expense means food expenses of horse. Extraordinary expense means if the horse fell ill suddenly, he called and basically you called the doctor expenses, that is extraordinary. Now in case beta, it is a non-gratuitous bailment, like Mr. B took the horse for some work, okay, so who will bear the ordinary expenses? Okay, Mr. B. Okay, ordinary expenses. If it is non-gratuitous bailment, who will bear the extraordinary expenses? Okay, it is who beta A. A will bear the extraordinary expenses. Why? Because boss, it is not because of B, no. The ordinary food expenses B will bear, but beta that doctor's expenses will bear beta A. But in case it is gratuitous bailment for benefit of bailer, okay, like I gave the dog, okay, to Suresh, it was gratuitous bailment for benefit of bailer. So here beta, that dog's food expense also will bear beta, it is me only who has to bear. So what I am trying to tell, it is a normal bailment, non-gratuitous bailment. Ordinary expenses bailee, extraordinary expenses bailer. But in case it is gratuitous bailment for benefit of bailer, then beta all the expenses who has to bear beta, bailer has to bear. Am I clear? Yes. Next, duty to indemnify bailee for premature termination. You remember I told, in case it's a gratuitous bailment, bailer can pre-terminate, take that car example, the bailment, but he has to pay net loss to bailee. Yes. Now bailer's responsibility to bailee. What is this? Just a second. Written here everything. First is duty to disclose faults in the goods. Okay. In case there is a failure, to disclose faults in the goods. Failure. Okay. Then, and basically it is a non-gratuitous bailment. Then bailee will be liable for known plus unknown faults. But in case it is a gratuitous bailment, then basically bailer will be liable for only known faults. Duty to pay necessary expenses. In case it's a non-gratuitous bailment, then extraordinary expenses bailee, or ordinary expenses. Ordinary expenses bailee, extraordinary expenses bailer. But if it is gratuitous bailment for benefit of bailer, then ordinary expenses plus extraordinary expenses will bear beta bailer only. Okay, then bailer's responsibility to bailee for to compensate bailee for loss incurred due to defective title of bailer. Like example, I bailed a bike, like I gave my bike for service to whom? To Mr. X.
He told after 3 days come and take the bike. Okay. But after 1 day only, beta, so I am the baler, he is the bailiff. After 1 day only the bike was serviced. And he polished the bike and kept it in his service center. One day, that day only, after 1 day, Mr. Y, ex ka friend, he came and he told, Arey, you took a new bike? He told, yes, my new bike, Hayabusa. Told, Arey, can you give this bike to me for 1 day? I'll pay rent. Okay. X is like, how much rent? Is like 25,000. Well, okay, take it. So see, X was not the proper owner. He did not have title, but he showed that he has title and bailed the bike to whom, beta? Y. Now between X and Y, X is bailer and Y is bailee. Now Y was riding the bike, and on the same road I was also driving my car. And I'm like, Arey, same bike like me. I'm like, Arey, it is my bike. I stopped him. I give my bike. I have the papers. So he's like, no, X has the bike. It is the owner of the bike is X. I'm like, hey, it is my bike. So he told, sir, what to do? Mala, give me 40,000 rupees. So sir, 40,000. Bola, ha? Or else give the bike. Rent is 40,000. Yes, sir. He gave me 40,000 because he was in the middle of highway. So basically, now Y had to expend 40,000 because of defective title of X. Can he recover it from X? Answer is yes. It is a duty of X to compensate him. Am I clear with this thing? Understood properly? Clear, everyone? Okay. Next, for expenses due to failure to take back the goods on time. It is the duty of bailer to take back the goods on time. If he doesn't take the goods back on time, then any expenses which bailee has borne for keeping the goods in safe custody, bailer has to pay to bailee. Understood? Clear? Like example, I gave the bike for 3 days for servicing. After 3 days, I should have gone and collected. I did not come for the next 10 days. Extra 7 days, okay, parking charges, who will take from me, beta? The bailee will take for me. Am I clear with this thing? Okay, so this is the duties of bailer. I hope everyone understood. Clear? Okay. Now, rights of bailer. First, terminate bailment. Tell me, beta. Example, I understand that I gave a dog to Suresh. Now, what Suresh is doing now, beta? Suresh is riding on that dog. Again, going to classes and all. Is that the purpose I gave? No. So, can I terminate the bailment there itself? Answer is yes. Clear? Understood? Then section 159, that same premature termination, it is my right. But yes, obviously I have to pay net loss to bailee in case of gratuitous bailment. Next, right to file suit against wrongdoer. Now this is interesting. Huh? See, example, I gave my car to Mr. X. Okay, I am the bailer, is the bailee, and Mr. Y, okay, damages that car. So me as well as bailee both have a right to file a suit on Mr. Y. Am I clear? So basically both bailer and bailee can sue. Now what is the point? Next point, compensation out of the suit will be distributed between bailer and bailee as per their interest in the goods. Section 181. So it's an interesting one. Okay. So what does this point tell, beta? Yes, sir, in case I bailed some goods, okay, to a bailee, and any third party beta damages the goods, tries to damage the good, okay, we can sue. We both can sue. That is section 180. And if we file a suit on him or we take an action on him, any compensation received, that compensation will be distributed between bailer and bailee as per their interest in the goods. Let's take an example. I have a car of 10 lakhs. I purchased a car. And there is a guy, Inam Bhai. He is my garage person. I gave the car for modification to him. Okay. I purchased the Thar. Okay. And I'm like, you do modification. Inam Bhai told me, sir, 5 lakh rupees will be for modification, new tires, new lights, everything. I told, okay, you do one thing, you incur the expenses, okay? Once the car is ready, let me know. So he incurred 5 lakh rupees on the car. Now, initially the car value was 10 lakh, now it is 15 lakhs, okay? Now, up till now I have not paid anything to him. So basically what is the ratio of interest in the goods?
My ownership is of 10 lakh, his ownership is of 5 lakh, 2:1. Now what happened now? One day one person, Kiran, intended to damage the car. He came to damage the car and basically he was caught and we filed a complaint against him. Okay, once we filed a complaint against him, beta, court gave us a compensation from him. How much, beta? 3 lakhs. Yes. Now this 3 lakhs will be divided amongst whom, beta? Amongst Harsh and Inam. In which ratio? 2:1. So I'll get 2 lakhs and Inam will get 1 lakh. Am I clear? Understood? Yeah. So, next one. Right to sue Bailey for. Beta, I can, as a bailer, I can sue Bailey for compensation against damage to the goods due to negligence of Bailey. Beta, if there is any damage to my goods because of Bailey's negligence, can I sue him for that? Yes. Then beta, compensation for unauthorized mixing of goods. Now what is this, beta? It is the duty of the Bailey, section 155, 156, 157. Duty of the Bailey not to mix Bailey's goods with bailer's goods. Like example, I don't know, example, you have a refrigerator at home, okay, and you made dosa batter and kept in your refrigerator. Your neighbor's refrigerator is not working properly. So he came and he requested, can I keep my dosa batter? He also had dosa batter in your fridge for one day. You told okay. So now beta, he is the bailer and you are the Bailey. Should you mix your batter and his batter? No. You should keep it separately. Yes or no? Can you mix it? Our is not that good. Let us mix. No, you cannot do it. So it is a duty of the Bailey not to mix bailer's goods with his goods. But in case he mixes, then what is the consequence of that? To see. The consequence is here. We have written. See. Section 155, 156, 157. Okay. It is the duty of the Bailey that Bailey should not mix his goods with the bailer's goods. But if he mixes, then there are two situations where he is mixing, or two circumstances. First, is mixing the goods with the consent of the bailer or without the consent of bailer. Example, he mixed the goods with the consent of bailer. So what is the consequence? Proportionate ownership of the goods will go to bailer and good will go to Bailey. Like example, okay, I had 50 lakh ka gold, you had 50 lakh ka diamond. You gave me the diamond, okay, to mix it in with the gold and basically make 10 ornaments, necklaces. I did that. So basically now beta, what will be the outcome? 10 necklaces were made. 5 necklace ownership will go to me, 5 necklace ownership will go to you. Simple. The Bailey or the bailer. Next, without the consent. But if I mixed your goods and my goods without your consent, then I did wrong. So one point is that I have to pay damages to you. But apart from that, what will be the consequence? First, what you will see, whether the goods can be separated or it cannot be separated. That is the first thing everyone will try to do. If the goods can be separated, who will bear the cost of separation? Okay, Bailey. Bailey has to pay cost of separation plus damages to the bailer. Plus beta, okay, in case goods cannot be separated. So now we will see whether this mixture can be sold, it cannot be sold. If the mixture can be sold, like example, you mixed, I gave you my dosa batter and your dosa batter. We are into the business of making dosas and selling. You mix the goods without my consent. What is the purpose? But can this mixture be sold? Yes. Okay. We can sell this mixture. Okay. Now, beta, after selling the mixture, we got better 200 rupees. 100 rupees you will keep, 100 rupees I'll keep. But beta, can I claim damages? Yes, because obviously beta, you mix the good without my consent. Basically, bailer can claim proportionate ownership plus damages. Am I clear with this? But if the mixture cannot be sold, like example, I had 1000 liters of petrol, you had 1000 liter of diesel in your godown. I kept it with you in your godown. I gave the petrol ticket to you. I bailed it to you, so that you can keep it for one day in your godown. What you did now, you mixed it. Now can petrol and diesel mixture, can it be sold? No. So what I can do, first as a bailer, I can recover the value of my petrol plus I'll claim damages from you. That is section 157. Understood properly? Clear? Yes, good. Sure. Next, right to sue Bailey for accretion to the goods. Okay. Now what is accretion? Value addition. Sir, value addition of the goods now, TK will always belong to the baler. So baler can claim value addition of the goods from the bailee. Like I'll give you example. I bailed a cow to you for 6 months. But in this 6 months, the cow gave birth to a calf. Now tell me, if the ownership of cow is mine, ownership of calf is also mine. Can you say ki, Arey, when the cow was with me, at that time the calf was born, so calf is mine? No. Any valuation of the goods, TK, will belong to baler only. Baler can claim it. That is section 163 itself. Next, sorry, this one. Section 163. Next is compensation for unauthorized use of goods. Like example, beta, I told you I gave my dog to Suresh. He rode my dog and basically the dog's back was broken. Now beta, it took me 2 lakh rupees for basically repair that thing. Okay, to make good the loss. So basically, can I claim that 2 lakh rupees? That hospital expenses, medical expenses from Suresh? Answer is yes. I can sue him for that. Understood? Next is demanding the goods back. But I gave you the goods for 10 days. After 10 days, beta, can I demand the goods back? Yes, it is my right. So these are the rights of bailor against the bailee. Okay, and the above one were the due. Am I clear with this thing? Understood? Did you understand all these points? If yes, give me a thumbs up. Yes. So now we'll take a break of half an hour, okay, and then we will continue. Rights and duties of bailee, okay, small point, and then contract of pledge and agency. 1 hour, and I think in 2 hours we'll be able to finish everything. Okay, sure. Half an hour break.
Okay, guys, let's continue. Yes, I can send the notes, and I'll send the notes. Don't worry. Now, beta, we are studying. We did rights and duties of bailer. I will study rights and duties of bailee. Let's understand. Sir, duties of bailee. Let's understand duties of bailee. Sir, in duties of bailee, first duty of bailee is to take reasonable care of goods. Section 151 and 152. What does that mean? Sir, understand. We just studied, beta. Sir, it is the duty of the bailee to take proper care of goods, as I told, which is section 151. But what does section 152 tells? If the bailee has taken reasonable care and there is a loss to the goods, who will bear the loss, beta? But basically, if there is no reasonable care taken by bailee, this bailey's default, and there is a loss to the goods, so who will bear the loss? Am I clear with this thing? That is what section 152 tells. Next, not to make inconsistent use of goods. Like that dog, Suresh started riding the dog. Can you do this thing? So basically, you cannot make inconsistent use. Okay, or else a bailer has two rights. First, he can read the contract void and rescind the contract. So I can take my dog back. Okay. And any damages happened, okay? I told you that back broke and all. Basically, he can claim damages. Okay? He can claim damages. That is 153 and 154. Next, return the goods on time. Return the goods on time. It is the duty of the bailer to return the goods on time. That is section 160. What does 161 tell us? Sir, if there is a failure, bailee did not return the goods on time. So see what happens if I have bailed the goods to you for 7 days. Within that 7 days, any loss to the goods, damage to the goods, proper care taken, I will bear. No proper care taken, you will bear. Bailee. But for 7 days, I gave the goods. After 7 days, also you are keeping the goods. After that, any loss to the goods, failure, then any loss to the goods, whether proper care taken or not taken, loss to goods will bear, beta, bailee. Am I clear? Yes. Then return accretion on the goods means any value addition on the goods takes place. That will, beta, who will be the owner of that? Bailer. Basically, it is the duty of the bailee to give back the value addition. That calf example we studied. Next, not to set up adverse title. Tell me, beta, when I do bailment, basically it is transfer of what, beta? Possession, not ownership. And so basically, if I bail the goods, okay, will you become the owner? No. So can you resell the goods? I clear with this thing. So, next, rights of bailee. Now, what are the duties we studied? Now, what are the rights of bailee? Sir, it is the right of the bailee to deliver goods to any one of the joint bailers unless otherwise agreed. That means, example, Sir Harsh, I took a car on rent. Okay. And basically from whom, beta? A and B. They are the owners of the car renting business. Then, beta, I returned the car. I returned the car. When I returned the car, beta, at that time, beta, only A was present. I gave the car to him. After 2 hours, I got a call from B. Arey, why did you return the car to A? He doesn't know driving. He dashed the car somewhere. Okay, now you have to pay the damages. Will I be liable to pay the damages? No, because it is my right to return the car to any one of the joint bailers, unless otherwise agreed. But if it is mentioned that yes, if I am returning the car, I should return it to B only, not to A. Then I returned it to A. Then it is my mistake. Am I clear? Next, right to indemnity, section 166.
It is the duty of the bailor to indemnify the bailee for this amount, and it is the right of the bailee to be indemnified. For what? For damages due to defective title of the goods, defective title of bailor. Do you remember? But I gave my Hayabusa for servicing to X. X gave it to Y. Then basically I took 40,000 from Y. Y can recover it from whom? X. So it is the right of Y to be indemnified, okay, for that 40,000 by Mr. X. Next, if the bailee delivers the good in good faith and assuming bailor as owner. Like example, my bike now was stolen by Mr. X. And then beta, he bailed it, okay, on rent in another state, Mr. Y. From sources, and Mr. Y believed him to be the owner. From sources I understood Mr. Y has the bike. I went to Mr. Y, told him the fact and will give me the bike. But by that time, in good faith, Y had returned back the bike to X. And now X is nowhere found. I am suing Mr. Y. Why did you return the bike? Okay, now any loss, now you pay me the price of the bike. Can I claim that money from Y? No, obviously not. He will be indemnified. Next, expenses incurred in under gratuitous bailment for benefit of bailor. Do you remember beta? Okay. In case it's a gratuitous bailment for benefit of bailor, any expenses, ordinary, extraordinary, who will bear? Bailor. So if bailee has incurred, bailor, it is his right to be indemnified by the bailor. Bailor has to reimburse that amount to him, to bailee. Am I clear with this thing? Next, compensation in case of faulty goods. That is the first duty of bailor. In case there are faults in the goods, he should inform the bailee. If he doesn't inform, any loss to the bailee, okay, bailor will bear. Depends, sir, for known fault, unknown faults, depends upon the type of bailment. Claim extraordinary expenses, section 158. Tell me any kind of expenses, extraordinary, ordinary expenses. Okay, sorry, any kind of bailment. Okay, gratuitous bailment for benefit of bailor, normal bailment. Okay, extraordinary expenses will be borne by whom? Bailor. So in case bailee has borne that extraordinary expenses, bailee can get it back from bailor. Apply to court to decide the title. If person other than bailor claims ownership. To understand, Mr. Harsh gave a bike for servicing to Mr. X. A bike for service. Now Mr. X has to give back, but at that time beta, there is Mr. Y. He came and he told this is my bike. So basically Harsh is telling this is my bike, Y is also telling this is my bike. He also has paper. It is the duty of X to give the bike back to H. But beta, what here X can do, he can apply to the court, ki sir, this is the situation, you decide. Am I clear with this thing? Understood properly? So that is the duty. Okay. Sorry, and the right as well. Tomorrow beta, what happens? Okay. Example, X went to the court and told ki boss, okay, see this is the situation, court you decide. Matter went to the court. After 6 months, court told ki the bike belongs to Harsh. Now example, we had in the contract of bailment, it is written that if X doesn't give the bike to me on time, per day 100 rupees will pay. I'm like, okay, I told you na X, it is my bike. It's been 6 months, I did not get the bike. You pay me 100 rupees per day for 6 months. Can I claim it? No. Understood properly? Next, right of lien. Now what is right of lien? Understand. See, lien I have written here. Sir, what is right of lien? Understand. Lien generally they don't ask nowadays, but you don't know, ICA can ask anything. Sir, what do you mean by lien? Yesterday we did Sale of Goods Act. What do you mean by lien? Right to retain goods of another. So basically lien is of two types beta. One is general lien, one is particular lien. Now what do you mean by general lien? Lien means lien on all the properties of another. Like have you watched, like example, Bank's lien? Have you watched this movie Shivaji the Boss? Okay, Rajnikant's. Basically that music is there na? It was like this. Before he becomes bald, at that time, when he takes loan for his educational institute, 50 crore rupees, he fails to repay it. So at that time beta, what happens? The banks takes charge of all the properties, creates lien on all the properties of his, including his Rolex watch. Yes or no? So basically that is general lien. What is particular lien? Particular lien means lien only on a particular property. Like Bailey's lien is generally a particular lien. I'll give example of this. Let's understand. Example, Mr. X gave a bike for servicing to Mr. Y, and Y is told कि sir servicing charges will be 10,000. Okay, Y is the bailee, X is the bailer. Now on the actual date, X came to take back the bike, and now X has to pay 10,000, and he's like, "Arey yaar, I did not bring my wallet." So he tells ki, "Arey why? I'll give you the money after 2 days." Okay. So will Y give the bike? No. Y will have lien on that bike. Am I clear? But he can have lien only on that bike. Example, beta. There was a mobile of X. So basically, Y asks you, whose mobile is this? X is like, my mobile. So can Y take the mobile? Okay, and give money and take back this mobile. No, he cannot create lien on all the properties, only on that specific property. That is specific lien, that is particular lien. Okay. Next is, beta, particular lien is implied. Like tell me, when you give a bike or car for servicing, does the person tell ki, if you don't give us money, servicing charges will not give the bike? No, it is obvious, it is automatic. Am I clear? It is implied. But beta, bank's lien, is it implied? No. The terms and conditions of the banks, everything is written when we take a loan. Obviously, but it is written that was, if you don't give us the repay the loan, we will create lien on all the properties. So it is not implied, it is not automatic, it is expressly mentioned. Next, particular lien, it is exercised against application of skill or labor on goods. Tell me beta, in this case, Y created lien on X bike. Why? For that 10,000, and 10,000 was for servicing. So can I say Y actually, okay, exercise skill, okay, labor and skill on the bike? For that he's asking 10,000, and against that only he's creating lien. Correct? Okay. But beta, general lien is generally not exercised against application of skill or labor on goods. Like that bank's lien, Rajnikant's case. Okay. Tell me beta, at that time, did the bank, okay, applied any labor or skill on the goods? Did they paint the bungalows and all of Rajnikant? Okay, and for that they are creating lien? No. It is because it is expressly mentioned. Sir, one more point. Okay. Particular lien section 170, general lien section 171. So in case you get a question, state the or distinguish between general lien and particular lien, so you can write this thing, but probability of questions being asked is less. Am I clear with this thing? Yes. So here we have completed beta contract of bailment. Am I clear with this thing? This should clear. Next. I hope you understood contract of bailment. If you understood, give me a thumbs up quickly. Very good. So, now, good. CA aspirant. What is your name actually? Name is, you are written CA aspirant. What is your name? Niranjan. Niranjan Patil. Is it Niranjan Patil? Yes, no? So, now let us start, okay, with contract of pledge. Now what is contract of pledge? Section 172. See, contract of pledge or contract of pawn, there are two names. Sir, what is this contract? Contract of pledge beta is a contract where there is bailment of goods as security against a borrowing or a debt. Now, first thing to sir, contract of pledge is a contract where there is bailment of goods. Sir, so pledge is a type of bailment? Yes, pledge is a type of bailment. How come? Understand. Now, branch. Example, I wanted a loan of 1 lakh rupees. I went to Mr. Vishnu and I told him, can you give me a loan of 1 lakh? So Vishnu told, okay, I'll give you a loan of 1 lakh, but I need some security. So what I did, I gave my wife's necklace as security. Now tell me, and he gave me loan of 1 lakh. Now tell me, this is a contract of pledge. Okay. Now tell me, is it a type of bailment? Yes, because here there is transfer of possession of goods from one person to another for a particular period or purpose. What is the purpose, beta? Security, obviously. Okay, with the condition that once the period or purpose is completed, like once the loan is repaid, the goods will come back to, okay, the bailer. Yes or no? So it's a type of bailment. So here, actually in contract of pledge, Harsh is called as pledger, or another name pawner. Vishnu is called as pledgee or pawning. But can I say here we are also bailer and bailee because it is a type of bailment. So, but the rights of bailer and bailee will also come here. Okay, same all those things which we studied. But apart from that, specifically under contract of pledge, what rights will I as a pledger get and what rights Vishnu as a pledgee will get, that we will study now. Am I clear? So see, rights of pawnee. First, rights of pawnee. Well, pawnee, who's the pawnee here? Vishnu. First is beta, right to retain the goods. Until I repay the loan, will he give the goods to me? No. So for what all amounts beta, he can create lien on the goods. He is a bailee here. First, debt amount. That is, until I pay principal plus interest amount, will he give the goods to me? Not possible. Next, expenses incurred on goods. Like for preserving the goods, he expended some money. Okay, so can he create lien for that? Yes, obviously. Okay. Next, beta, subsequent debt. Now, what is subsequent debt? Okay. For subsequent debt also he can create lien, but only if it is agreed. Now, what do you mean by that? See, section 174. Understand? See, example, I took loan from Muthoot Finance and created a pledge, okay, on my gold. Okay, and this loan is example of rupees 5 lakh. Now Muthoot Finance sends me WhatsApp message. Okay, sir, as you are eligible, you are a premium customer, you are eligible for rupees 1 lakh personal loan. Now this is secured or unsecured? Unsecured. Now I took this loan also. Now, okay, after some time I repaid 5 lakh rupees ka gold. So should Muthoot Finance release the gold or not? Yes. What they are telling, sir, you are not repaid this 1 lakh, so we will not release. No, they don't have the right to return this because this loan was not agreed on the basis of same security. If it is agreed, then only. Am I clear with this thing? Okay, that is section 174. Next, if pawner defaults, sir, if I don't repay the loan, can the pawnee sell the goods? Yes. But after selling the goods, if he gets more amount, more than the debt amount, okay, can he keep it? No, he has to give it to me because I am the owner. But sir, in case he gets less amount, can you sue me for deficiency? If pawner defaults, pawnee can sell the goods, section 176. Okay, but if sale proceeds are more than the debt amount, pawnee shall pay the surplus to pawner. But if sale proceeds are less than the debt amount, then pawnee can sue the pawner for deficiency. Clear? Now, next we'll study rights of pawner. What is rights of pawner? Let's understand. This is my rights. Well, first is right to redeem, section 177. What is right to redeem? I will repay the loan and get my goods back. Simple. That is right to redeem. Very simple. But beta, right to redeem I'll have at the due date or on the due date as well as post due date. Okay, provided goods are not sold to third party. Okay, now what does that mean? See, example, I took a loan from Vishnu for 1 year and there is a date. On that date I have to come and repay the loan. On that date I went and repaid the loan, I can claim my goods back. That is redeeming. But I did not go on that date. I went after 6 years from that date. Now beta, after 6 years I went and I'm like, give my goods back, I'm ready to pay debt amount plus interest of that extra 6 years. Okay, and I'm claiming the goods. To tell me beta, can I claim the goods, or it is the right of Vishnu to tell I did not come on due date? Okay, so it is his goods, I cannot claim it. Answer is no. It is my right to claim redemption after that also, because I'm ready to pay interest. Condition is that Vishnu should not have sold the goods to someone else. If he has sold the goods to third party, then it is his rights, not third party's ownership. Then I cannot claim redemption. Am I clear with this thing? Understood properly? Next, pledge by a person having limited interest, section 179. Now what is this? It's a beautiful topic. I always tell this thing to repeat like this. Okay, a person having limited interest in the goods can pledge the goods up to the value of interest he has in the goods. Okay, the question is, can a pledgee further pledge the goods? Answer is yes, okay, on the basis of section 179. Now see, example, what I'm trying to do. Harsh, I had gold of 10 lakhs. So can I say I have general property, sale of goods, complete ownership in the gold of 3 lakhs, oh, sorry, 10 lakhs. But I pledged the gold with Vishnu for 3 lakhs. Now until I repay the loan, can I say Vishnu is the owner of the gold for the value of 3 lakhs? Basically, Vishnu has limited interest, limited ownership of gold of 3 lakhs. Tomorrow if Vishnu is in need of money, okay, Vishnu can pledge the same gold to Mr. A example, okay, and take loan. But that pledge will be valid only up to the value of 3 lakhs, not more than that. If it takes a loan more than 3 lakhs, but then only up to the value of 3 lakhs it is valid. For that extra 1 lakh it is not valid. Am I clear with this? Understood properly? Clear? Now, next is section 178A. This we studied in Nemo, that code non-habit. Okay, that Harsh Garuda wala example, same to same example, but rather than pledge, sorry, sale, it is pledge. See, pledge by a person in possession of goods under voidable contract is a valid pledge for bona fide pledge. Same example, I took a car of 4 crores from Garuda, okay, for 1 crore by showing a gun. Yes, Garuda went to the court, but until the court order came, what I did, I pledged the car with Ranveer Singh and took loan of some amount. After some time, Garuda came with the court order, this is a voidable contract, okay, give me the car. I told I don't have the car, it is with Ranveer Singh. Can Garuda claim the car from Ranveer Singh? Answer is no, until the repayment of loan. Because Ranveer Singh is a bona fide pledgee and that pledge is valid for him. Am I clear with this thing? Understood? So basically, until Ranveer Singh gets the loan repaid, he will enjoy that car. Understood properly? Clear? This were the main, okay, sections in terms of rights and duties of pledger and pledgee. Please do these things properly. Take a probability of these things coming in the exam is high. Okay, rest obviously can come. Okay, but as far as I am concerned, okay, so these things are, I feel it is very important. So basically, contract of pledges come to an end. Okay. Now, the last contract is contract of agency. Let's start with contract of agency. Niranjan, how much is code in law? This attempt. How much is code? Very less. What went wrong? You did not remember things up properly. What went wrong? Not study properly. Okay. You have the paper answer sheet. You have the paper answer sheet. No. Just through RT I try to take the answer sheet. Send it to me. I'll check it. What went wrong? Okay. Because if you are getting 18, trust me guys, people who are getting 25, 20 or in whole, even if you are getting in accounts better 45, 48, so there is something wrong in your preparation. Trust me. Okay. You are doing a big mistake during preparation. And until you solve that big mistake, beta, you will not be able to clear the exam. Something big mistake you are doing in preparation. What might be the mistake? 90% probability the mistake is that you are not writing law in law paper. Okay, like example, you get a question. Okay, just randomly let me take one question. I'll take this question. Now guys, chalo, we'll see what you will answer. Okay, question number 16. Miss Shakuntala puts an application. Okay Anish, no problem. Miss Shakuntala puts an application to be a teacher in school. She was appointed by the trust of the school. Her friend who works in the same school informs her about her appointment informally. But later, due to some internal reasons, her appointment was cancelled. Can Shakuntala claim for damages? Now, what? Just write in short, what will you write in the answer? Everyone, go ahead. I don't want answers. No, she can claim, can't claim, and all. What will you write in the paper? Now I'll tell you why didn't you score marks. Now, see, when you read the question here itself, beta, the moment you see the question, beta, the provisions should strike your mind. Like, now, what is this? The moment I read the question, I understood it is a concept key that Shakuntala made an offer. Okay, it's a specific offer. Who should accept the offer? Okay, the school. And who should communicate who should communicate the acceptance? The school. But who communicate acceptance? Her friend. Okay, so can the friend communicate the acceptance? No. So is there any contract between them? No. So basically on that base, so basically it is a concept of specific offer. So for specific offer, is there any case law? Answer is yes, it is Bolton versus Jones. Okay, that was acceptance has to be given by the person who has the authority to accept. Bolton versus Jones. So what I'll write first. Okay, in the case of Bolton versus Jones, okay, right, so Jones was creditor, I have to explain the case, creditor of a person called as Brocklehurst. In order to get his debt paid, he placed an order of goods with Brocklehurst because Brocklehurst was not paying his money, he was a manufacturer. However, Brocklehurst had sold his business to Mr. Bolton, who received the offer letter from Jones and supplied goods. Mr. Jones refused to pay, contending that the offer was not in the name of Bolton. Then I don't have space here, I'll write it here. Held that as it is a specific offer, it must be accepted by Brocklehurst and not by Bolton, and hence no contract exists between Bolton and. Then you have to repeat facts of the case. In this case, Shakuntala this. Okay, Shakuntala made an offer later, made an offer. Okay, then has made an application to the school. School decided to appoint her, but was not communicated to her. Her friend communicated. Later, the school decided not to appoint her. Now Shakuntala wants to claim damages. Now, then the third opinion, referring to the above provision, we are of the opinion that Shakuntala cannot claim damages as it was a specific offer made by Shakuntala and the school must be the one who should communicate the acceptance, not her friend. As the school did not communicate the acceptance, there was no contract, hence she cannot claim any damages. Now tell me, did you write answer? Did this thing came in your mind, this format? If answer is no, then better the problem is there. If there is a case law, you have to first write the case law and explain it. Here indirectly what they are asking you now. Okay, in short, Shakuntala question, how, what, in simple short if I explain, it is the acceptance must be given by a person who has the authority to accept. Explain the statement referring a case law. This is what they are asking. So if you write and you don't write the case law, basically you will not get the marks. But if case law is not there for this, what you will write, beta? Yeah, as per the provisions of Indian Contract Act, in case of, if there is a specific offer made, okay, only the person who has the authority to accept, okay, should give the acceptance. Okay, or you can write, but as per the provisions of Indian Contract Act, acceptance must be given by the person who has the authority to accept. In case of general offer, Okay, any person who has the knowledge of the offer can give acceptance, and in case of specific offer, only the person to whom offer is made should give acceptance. This will be the provision in case case law is not there. Okay, then facts of the case and opinion. In case there is a case law for that, write the case law. If explain the case law. Okay, try to by heart the case law, no problem. Okay, for passing, if you want to do it, do it. Okay, but if there is no case law, then basically the exact provision you have to write. Now, this is what your preparation should be. If your preparations are not good enough, okay, then you will always end up writing like this question. Now I'm taking actual lecture also, like not a crash course, a normal lecture. I ask this question, so what students say, Shakuntala cannot claim because it was not formally informed to her. Okay, it was randomly informed to her. These words students are writing, telling me. So did they give me law or did just they give me logic? Logic. For logic, you are not going to get marks. It's not logical reasoning paper, it's a law paper. Am I clear with this thing? Understood? If you understood, give me a thumbs up. Great. Okay. So try to, when you study at that time, whenever provisions come, okay, case laws come, please mark it. You have to do it properly. Randomly, when you cannot just randomly study and I remembered, I understood and go in the paper. No. Like how you practice accounts 2-3 times, how you practice maths 2-3 times. For law also institute tells you have to write it and practice 2-3 times. Okay, then only you will clear. Yeah. Perfect. Your preparation will decide how you will write the answer. Trust me, if I tell you, see, I told you this thing, then I'll tell you another case law how to write. But unless and until you have not done the preparation, you'll always have this question, sir, how to write answer? Sir, ये समझ में आया, दूसरा आंसर बताओ ना, third answer tell ना, fourth answer tell. How many answers can I tell you? Am I clear with this? Your preparation will decide how you will write the answers. Am I clear? Yes, don't do the mistake again. You will all clear ticket. Study properly. That's it. The portion is so big. How to remember everything? ICA tells it is your problem. When you get this much salary, do you tell ICA, sir, how to store it? No, no. Basically, ICA tells it is your problem. I'm telling you now. It depends upon Anish Veda. How much you score? How much you scored? 49. See, but if you had written in this format, okay, so see, if you just write, if there is a case law for Bolton versus Jones was there, but you did not write, but you wrote about the provision. The offer must be accepted by the person who has the authority to accept. In case of general offer, anyone specific or only by the person who has to whom offer is made. That is also correct. But case law, there is a case law, but you did not refer. So out of 4 marks, they'll give you 2 marks. But if you write like this, they'll give you 3 marks. So rather than 49-50, you could have scored better 60-61. That difference is there. Am I clear? Understood? So this small extra effort will give you 55, 60, 65 marks. Okay, or maybe 75 also. But this small laziness, sir, who will write everything again, practice everything? Okay, then you will end up getting better 35, 30, 32, 40. Am I clear? It is not storytelling, no, it is law. You need to be very strict as to the provision. Okay. Now, sir, the last type of special contract is contract of agency. Now, what is contract of agency? Let's understand. Sir, no, Indian Contract Act defines indemnity under section 124. It defines guarantee under 126, bailment under 148, agency under 172. But Indian Contract Act doesn't define agency. Agency is not defined anywhere. But yes, who is an agent, that is defined. That is explained. So who is an agent? That agent means a person. If you come under any of the 3 points, you are agent, and the person appointing you is your principal. First, agent means a person who acts on behalf of another. Like you sell my goods on my behalf, so you are my agent, I am your principal. Second, a person who represents another. Like you are my chartered accountant, you represent me in front of income tax commissioner, you are my agent, I am your principal. A person who brings principal into contractual obligation with third parties. Like your dad wants to sell a property, so he appoints a broker. So broker doesn't sell the property, broker just arranges a buyer. So the broker brings your dad into contract with third party. That broker is also an agent, and the person is appointing him is a principal. Now, test of agency. Whether you are my agent or not, what is the test? See, it is told that agent never acts on his own, he acts on behalf of principal. So if you do something and it would be as good as I am doing that thing and I am bound by that. If you do something, I am making profit, or you do something, I'll make loss. Okay, so I am bound by that. You raise your hand, it is as good as I am raising the hand. You sold a property, it is as good as I sold the property. So whatever you do, if I am bound by that, then you are the agent, I am the principal. Am I clear with this thing? If one person is bound by the act of another, there is agent principal relation. Now beta, there are certain essentials of agency. Now what are the essentials? Sir, basis of an agreement. Sir, contract of agency will come out of an agreement. Okay, we are studying contract of agency, so there should be an agreement. Now what is that agreement? The agreement tells, okay, that whatever agent does, it is as good as principal is doing. Whatever agent does, okay, profit will be taken by principal, loss will be taken by principal. If it is there, okay, if this relation is there, then there is agency. This is what is the basis of agreement. Am I clear with this? Next, consideration is not necessary. Sir, in order to form agency, consideration is not necessary. Do you remember, beta, we have done that? Okay, under Indian Partnership Act, one partner is the agent of another partner. Okay, by default of law. Do we pay any commission? No. Principal must be competent to contract. Agent may or may not be competent to contract. Like I tell na, it is told that beta, agent is just a shadow of principal. So if principal is the main person, like if my hand is there and this is the shadow of the hand, if I move my hand, the shadow also will move. If the hand cannot move, will the shadow move? So basically, who should be competent to contract? Principal. Agent may or may not be competent to contract. Maybe the agent may be a minor also. Sir, how can be an agent minor? I'll tell you. See, example, Mr. X is my brother. He's 17 years old. Okay, I am not in Bangalore. Okay, my hometown. I went to my hometown, and postal authorities called me. Sir, some books have been received. Okay, so it is there in the post office. Can you send someone to collect it, or can you come to collect it? I told I can't come. My brother will come. I gave his detail, my brother's detail. He'll go and collect. So my brother went and collected. So basically, if my brother has collected the book, it is as good as I have collected. See, he is minor, but can he be my agent? Yes, he is an agent of mine for the postal authorities. Am I clear? That is the point. Clear, everyone? Okay. So principal must be competent to contract. Agent may or may not be competent. Next, sir, modes of agency. Now, sir, agency can be created via different modes. Not only one method is there, different modes of agencies are there. First is expressed agency. Express means what? Express contract. Found by using words. I tell expressly that Mr. X is my agent. So basically express agency. Implied agency. Implied means without using words. Like we say franchises. McDonald's has many franchises, but does McDonald's officially tell you are my agent? No. But basically, if a franchise is selling something, McDonald's is selling from that. This is implied agency. Am I clear? Next is agency by estoppel. Now what do you mean by estoppel? Estoppel means to stop. Agency by estoppel tells, okay sir, if I represent third party that somebody else is my agent, any act done by that somebody else with third party is as good as I am doing it. Later on, but I will be stopped if there is a loss. I'll be stopped from denying the fact that I represent that there's somebody else, that he is my agent to the third party. I'm bound by the acts of that somebody else. Now, example. This example, if I'm not wrong, I took this example taken Bangalore batch. So I'll take the same example. I give example of this girl, Urfi Javed. Example, Urfi Javed is my sister. Okay. And she's a disaster in fashion industry. I'm into textile, Harsh. One day she comes to me and she's like, I want to do textile business now. I told, for textile business you need to have raw material. Now, nobody will give you raw material, I know that. But she's like, I want to do business, what to do? So I told her, do one thing. There is a guy, Mr. Niranjan. He gives raw material on credit to me. Do one thing, I'll tell him that you are my agent. I'll show that you are my agent. And I'll tell him to give goods to you, raw materials. For how much time you want raw materials on credit, then you will make payment. She tells 3 months. Now I tell Niranjan that Urfi is my agent. Give her the goods. But I did not tell him 3 months ka clause. So basically now Urfi started taking raw materials on credit. Now after 6 months, Niranjan called me, sir, you have not made the payment of the raw materials purchased by your agent. Like, that 3 months ka credit. No, well, they're not 3 months. Since 6 months she is buying it. Yesterday also she purchased. So please make the payment. Now can I say, no, we have an agreement, she can buy goods only for 3 months on credit on my behalf? No. I'll be stopped from denying the fact that I represented Urfi Javed as my agent, okay, to Niranjan. I am liable for that. Now, am I clear with this thing? Understood properly? Clear? Okay. Next is agency by operation of law. Now, what is agency by operation of law? Sir, I told you just now that there are some laws in India which tells that there is agent principal relation between people. Okay. So these laws only tell you two people will be coming under a contract of agency. Okay. So see, husband and wife. Wife is the agent of husband for necessaries of life. We studied earlier. And necessary as per my wife or as per law? As per law. If my wife purchases some necessaries, it is as good as I have purchased the necessaries. Second, one partner is the agent of another partner under Indian Partnership Act. That Partnership Act tells. Very simple. Next, agency by necessity. Now, what is agency by necessity? Let's understand. Sir, should an agent act within authority or outside authority? Within authority. But sir, if he does anything within authority and there is a loss, who will bear the loss? Principal. But if an agent acts outside authority and there is a loss, who will bear the loss? Okay, agent. But if he acts outside authority in order to save me, principal, from losses, then who will be liable, beta? Okay, then the principal will be liable. That is called as agency by necessity. But beta, whether there is an agency by necessity and the principal should be liable for the loss, okay, for that beta certain conditions have to be fulfilled. Now in our example we'll see beta whether the conditions are fulfilled or not. In your book there is a question. For example, Harsh, okay, I am the owner of tomatoes. I appointed Rahul a transporter, okay, who supplied tomatoes, transport tomatoes from point A to point C. Okay. Now he is the agent, I am the principal. He reached point B and it was very heavy rainfall. Okay. And basically there was flood ahead. Okay, a truck cannot go ahead. Okay, it will sink out until these floods are there. Now, okay, there is no mobile, nothing is there. Okay. So what he did, now tomatoes will perish. So he sold the tomatoes. Now actual value of tomato is
20 rupees kg, but he sold it for 15 rupees kg, or else tomatoes will perish because 20 rupees kg nobody was buying. Now, okay, later on Harsh understood the fact. He told, boss Rahul, you had the authority only to transport tomatoes, okay, not to sell. You exceeded authority. Now this 5 rupees loss I will not bear, you will bear. So should Rahul bear this loss? This is agency by necessity, but whether the conditions are fulfilled, which the law tells. Let's see the conditions, whether the conditions were fulfilled or not. In our case, communication with principal was not possible, obviously, that situation. That was a commercial necessity, or else better tomatoes will be perished. Agent acted bona fide to save the principal. Agent adopted the most reasonable method. Like boss, okay, he started selling it for 20, but nobody was buying, so he sold it at 15. An agent should be in possession of goods. Was he in possession of goods? Yes, obviously. Okay. So all these conditions are fulfilled. Now, beta, who will bear the loss of 5 rupees? It is Rahul or Harsh. I have to bear the loss. Am I clear with this? Okay. Now, the next is agency by ratification. Now, what is agency by ratification? I'll tell you. Ratification means approval or acceptance. Now here, okay, example, I am a diamond merchant, okay, and Preeti is a valuer, and Niranjan is also a diamond merchant. Okay, so what happens whenever I buy diamond? Okay, I take valuation services of Preeti. Like she's always there with me in the meeting. She advises me what should be the value. Okay, and then whether I decide whether to buy it or not. So she just can give me advice. Is she my agent? No. Can she buy diamond on my behalf? No. One day what happened? Preeti goes to Niranjan and tells, boss, I want to buy a diamond on behalf of her, sir, as I am his agent. Now what Niranjan thought, na, ki, okay, Preeti is always there with him. So he assumed that she is my agent. For which diamond she took a diamond. For how much, 7 crores. And all her sir will pay after 10 days. He assumed it. Now tell me, was she my agent actually? Now, after 10 days, Niranjan calls her, sir, pay me my 7 crore. I will pay 7 crore for what? He told me that Preeti came to take diamond on your behalf. She is your agent, right? I told, what is the value of diamond? Like 7 crore. 7 crore. I'll give you a call back. Just a second. I directly addressed Preeti and Preeti's house and basically started bombarding on her. I told I'll call the cops. Did fraud with me. She told Shant, sir, Shant. See this report. I saw the report, and in that report it was like she purchased the diamond for me only on my behalf. Value for what price she purchased? 7 crores. But the market value of the diamond is 10 crores. I can make profit of 3 crores. She's like, sir, now call the cops. I'm like, no. You are my agent. Right? Joke. Now tell me, see, she was not my agent. She acted as my agent. She pretended to be my agent. Later, I accepted her as my agent. That is called as agency by ratification. Am I clear with this? Okay, now I'll pay 7 crores to him. Understood properly? Clear? That is agency by ratification. Clear, everyone? Yes. Now, agency by ratification, there are some terms, okay, which we need to understand. Sir, in agency by ratification, it is told that, boss, I have to intimate Niranjan about the ratification. I have to communicate the ratification to him within reasonable time. It can be expressed or implied. Very important, beta. Okay. A ratification which will affect the rights of third party cannot be done. Like example, there is an example in our book. The example, sir A is there. He appointed B. Okay. He gave his house on rent. B is a tenant, and as per a contract, it is written that if I have to remove B, I have to give 3 months notice. So it is his right to receive 3 months notice. Now C is my son. C goes to B and tells, I am the agent of Harsh. Was he my agent? No. Okay. And he tells that, boss, I'm the agent of Harsh.
Okay, you have to vacate the house. Okay, I'm giving you 1 month period to vacate the house. Now beta B calls me and tells me, sir, is your agent, he's telling to vacate after 1 month? If I say yes, so I'm doing ratification. But by doing that ratification, am I affecting the right of B to receive 3 months notice? Yes. So will that ratification be allowed? Answer is no. Am I clear with this? Yes. So ratification which affects the right of third party, okay, is not a valid ratification. Clear everyone? Yes. Okay. See. Here ratification points are there. We'll read those ratification points. Important. These are important. Tomorrow is the last day, na? Day after tomorrow it is maths, right? It's maths. Maths is the crash course, fast track. Yes or no? So gaya kya re? Namuno. Which subject is there? Ratification. Ratification may be expressed or implied. Okay. Knowledge requisite for valid ratification. That means beta, whenever I ratify anyone's act, tell ki ha, whatever he did is he is my agent. I should have complete knowledge of that. If I don't have complete knowledge of that, it's a fraud against me. I can cancel my ratification. Okay. Effect of ratifying unauthorized act forming part of transaction. Like example, okay, when I ratify na, I can ratify, but I have to ratify the whole act of that person. Like example, beta, Preeti purchased, okay, 2 diamonds. In one I had profit of 3 crore, in one I had the loss of 3 crore. So can I say beta ki she is my agent for one diamond, not for other? No, partial ratification is not allowed. Either I have to ratify entirely or reject entirely. Ratification of unauthorized act cannot injure third person. Just now I told that ABC ka case. If beta I ratify C as agent, so his 1 month notice will be valid. But will the law allow that? No. Okay. Because it was the right of B to receive 3 months notice. Ratification has to be communicated within reasonable time. Okay. Act to be ratified must be valid. Beta, can I ratify illegal acts? No. Like example, okay, I told B that go and kill C. Okay, whatever happens to you, okay, I will ratify it. I'll save you from losses. I'll save you from police. Okay. Now beta B goes and kills C. Okay. Now police catches me B and he's like, "Arey, I am agent of A. A will save me." Beta, am I required to ratify it? No. The reason is that I'll tell you valid. This is the main transaction. This is illegal. So if the main transaction is illegal, collateral agreement is void. So there is no agent principal relation for that. Illegal acts cannot be ratified. Am I clear with this? Understood properly? Yeah. Here one example is that payment of dividend out of capital. Like whenever in a company beta dividend is paid, it is to be paid out of free reserves and profits. Can you pay dividend out of capital? No. Example, company's board of directors paid dividend out of capital. Can the members say, okay, no problem? No, it's not allowed. It is illegal. Okay. I hope everyone understood modes of agency. Yes. If yes, give me a thumbs up quickly. Yeah. So now next is substituted agent and sub agent. Now this is very important.
Please pay proper attention. Beta, there is one agent, principal agent. Okay, then beta there is substituted agent and sub agent. Now you need to know properly about substituted agent and sub agent. Now who's substituted agent? But a substituted agent means an agent appointed by original agent taken in his place. Like I appointed X as a agent for doing share trading on my behalf. Now X is my agent, but due to some SEBI regulation he was not able to act as my agent. So he appointed Y as my agent in his place. So Y is a substituted agent. Now for me he is as good as agent. Now whatever Y does, will I be bound by that? Yes. Okay. If Y does something and there is a loss, I will bear the loss. But what is written here, see, an agent appointed by original agent in his place is substituted agent. Principal is liable for the acts of substituted agent except where his appointment was without diligence. Means beta, example X, when he appointed Y in his place, he verified Y is a stable person, he is a solvent person, he has knowledge of share trading, experience of share trading, and then beta he appointed, and then Y acted on my behalf, did trading on my behalf, and there is a loss, so I'll bear. But beta X randomly beta, like say 10, 20, 30, 40, 50, 60, 70, 80, 90, 100. Who's that? Y. Okay, you become the agent. Randomly if he did this thing, so obviously it is negligence from his side. So in case now Y acts on my behalf and there is a loss, should I bear the loss or X should bear the loss? Answer is Mr. X will bear the loss, the original agent. Clear? Yes? Now sub agent. Understand properly. But a sub agent means what beta? An agent appointed by original agent under him. Let's take an example. Harsh appointed X as an agent for two things. Now X entered into a contract of agency with Y. Now between X and Y, X is the principal and Y is the agent. And out of these two things, X told agent, the sub agent, that you do that one thing. So Y is a sub agent here. So between X and Y, X is principal, Y is agent. But in this whole scenario, Y is the sub agent, agent of the original agent. Now actually now, as per Indian Contract Act, an agent cannot appoint sub agent, not allowed, but except in 5 situations. Now these are the 5 situations where it is told that a sub agent is properly appointed. And if a sub agent is properly appointed, then principal is bound by the acts of sub agent. That means beta, there are 5 situations. Apart from this 5 situations, if sub agent is appointed, principal is not bound by that, because that sub agent is not properly appointed. So when can I say that beta, a sub agent is properly appointed and principal is bound by that? Okay, so see, bound by the acts of sub agent. 5 situations. I'll tell you which 5 situations. An agent appointed by original agent under him. Principal is liable for acts of sub agent if he is properly appointed. Now what do you mean by properly appointed? First, principal allowed the appointment, sub agents. Principal allowed sub agents appointment. Second, principal knows about the appointment of sub agent but does not object. Third, customs of trade permit. That means, sir, like here, listen, we are into some business. Like example, we are into gold business, and in gold business it is a custom that agent can appoint sub agent, so he can appoint. Okay, but if it is not a custom, then he cannot. Next, act is ministerial. That means, do you remember, for one thing X appointed Y as an agent for one thing. That one thing did not require skills. Like example, transporting the goods from one place to another, it doesn't require any skill only. And then beta, there was a loss to me in that transportation, so it is my fate what to do. Even if X would have done, then too the accident might have been committed. If Y is doing better, it happened, accident arose. What is that? It is my fate, what to do now? Am I clear with this? I have to bear the loss. Next, emergency situation. Like beta, X appointed Y as a sub agent to act on my behalf in emergency situation to save me from losses. Then it is fine, then I have to bear the loss. So which are the 5 situations where beta agent can appoint sub agent? First, generally no, but yes, first,
Okay, principal allowed the appointment. Second, principal knows but does not object. Customs of business allow. Fourth, act is ministerial, that is which doesn't require any skill. And fifth, emergency situation. So these are the situation where it is told that sub agent is properly appointed and principal is liable for the acts of sub agent. Okay. Now there is sub agent answerable to principal. Sub agent does something and there is a loss. Can principal ask question to the sub agent? Now see, there are two situations. First situation is that he sub agent is not properly appointed. So anyways, but a principal will not bear loss. So why will he ask question also? But if he is properly appointed, then principal is liable. But here also principal cannot ask any question to sub agent because sub agent is not the agent of principal. He is the agent of original agent. But in two cases, better sub agent is answerable to principal. First, if sub agent is doing fraud with the principal, can't the principal ask? Yes. Second, sub agent is doing negligence. Like beta, take care. X appointed Y, okay, to deliver the goods, okay, from the godown, okay. And basically, before delivering the goods, you have to do PDI, pre-delivery inspection. Okay, there are 10 methods, 10 checkpoints you have to do see and then deliver the goods. Why is not doing that? He is just randomly delivering the goods. So it is negligence or not? So for that beta, take a can principal ask question to the sub agent. Why the hell are you doing this thing? And there is a loss to the principal. Who will bear the loss now? Am I clear at this thing? So basically, okay, in case of fraud and negligence, sub agent is answerable to principal. Okay, apart from that, take a and for any other thing, sub agent is answerable to original agent, not to the principal. Clear? Everyone understood? Okay, so, good. So 2 minutes break I am giving you now. Okay, after this we will start. So now better, three things are left. One is I have to tell you rights and duties of agent. Second, liability of principal and agent towards third party. And third is revocation of agency. That's it. So this part will also come to an end. Okay, 2 minutes. Now let us study. Okay. Now guys, let's understand. Now we have to do rights and duties of agent, guys. Now understand rights and duties when we'll study now. Rights and duties are actually very simple. You can see it's kind of common sense only. So when will you get marks for writing rights and duties? Now questions will come from rights and duties. Please write section number. For rights and duties, section number will hold weightage. Good amount of weightage. Am I clear? So rights and duties, please write section number. So see, first duties of agent. Execute mandate. Tell me, agent has to follow the principal instructions of principal, or he doesn't have to follow? This follow. But in case he doesn't follow the instructions of principal and there is a loss, who will be liable? Beta, agent is liable for compensation. Simple. Next, duty to act within authority. Sir, agent must act within authority, and if he does anything within authority, okay, any loss, principal. But if he exceeds authority, if there is any loss, then beta, it is the agent. But only one situation he can exceed his authority: in emergency situation. If agent acts outside authority, he is liable for any loss except in emergency situation. Reasonable care and skill. Obviously, if you are an agent, I appointed you for share trading on my behalf because you have the skills of that. You should use the skill. If you do not use your skill, so you are negligent. On account of negligence, if you do trading on my behalf, there is a loss, so you will be bearing the loss. If his agent is negligent towards his work, he will be liable for loss occurred. Communicate principal in case of difficulty. Like sir, in case there is a situation where agent doesn't understand what to do, so he should first communicate to the principal and then better he should act, or else it will also be treated as negligence. Like example, I appointed you as an agent to buy shares on my behalf. I told buy shares on my behalf, and this is an example you understood. You're about to buy, but you understood better. US share market crashed. The whole world market will crash by default, yes, and prices will go down. It will not go down. It will basically it will be dead down. So should you buy the shares now for on my behalf? No, you should talk to me, and then better whatever I tell you should do it. Am I clear? Next, duty to avoid conflict. Now what is duty to avoid conflict? It means beta, sir, whenever you act on my behalf, you should give me complete details. If you do not give me complete details and make some secret profit, I have two options. First, cancel the whole transaction, and second, keep the transaction, but what profits you have made without disclosing me, that I can take back. Am I clear? So inform principal about material information. Failure, you don't inform. An agent deals, then principal can cancel the transaction, section 215, or claim benefits from agent. Like example, I appointed you as my agent, okay, and I told you, you purchase goods from me on maximum rupees 100 per unit. You purchase goods on my behalf at 120 per unit, telling it is good quality. I trusted you. Later on, I understood ki boss, this goods are your goods only. Okay, value is 100 rupees only, and basically you did not tell me, okay, and purchased it on my behalf for 120. So now, okay, what I have option? First, I can cancel the whole transaction and give my 120 back. Or what can I do? Okay, I can keep the transaction, but the 20 rupees extra which you made na profit without telling me, basically that I can claim back. Am I clear with this thing? Good. So duty not to make secret profits, same thing. Next, duty to render proper accounts along with vouchers. Yes, along with vouchers is important. Okay, like when I give franchisee to you, okay, so you have to submit me accounts, okay, for profit sharing, but along with accounts you have to give me voucher also. If you don't give me voucher, you are not doing your work properly. One question comes, sir, Example, X had purchased this goods for 100 rupees and then sold it to you for 120. Then too he has to tell it, yes, he has to tell me that he is making a profit of 20 rupees. Duty not to delegate. I told you, can I agent upon sub agent? Generally no, but except in 5 situations. One of the situation is mentioned here, unless trade, customs or business permits. Next, duty to pay sums received for principal. Like if you are the agent of mine and you received 5 lakh rupees on my behalf, can you keep it in your pockets? No, you have to give it to me, obviously. Duty not to use confidential information against principal. You are my chartered accountant, but you are also the chartered accountant of my relatives. Can you tell all my bank balances and all to my relatives? No, obviously not. Okay, these are the duties. I hope you understood the duties. Okay. Next, rights. Sir, it is the right of the, see, when we studied here, we studied better. If you received some money on my behalf as an agent, you have to give it to me. But out of that 5 lakh, you can deduct some money, some amount, and give back me the balance. So what are the things you can deduct? First, retain expenses made on goods. Like example, you did some packing, you expended on packing material, okay, of my goods. So basically that you can deduct. Advances made for principal, like you purchase raw material on my behalf. So basically that you can deduct. Then you can deduct your commission. Section 217. Sir, if I don't pay you commission and you have my goods, can you create lien on the goods? Yes, obviously. If not paid, agent has a right of lien on goods of principal. Section 221. Next, obviously, is it your right to claim remuneration from me? Yes. But on which transactions? The transaction where you exercise skill, not negligence. Except where negligence was exercised. 220. Next is right to be indemnified. It is your right to be indemnified if you means you are the agent X and I, Harsh, am the principal. So it is your right to be indemnified by me for lawful expenses made. What is lawful expenses? Like example, I gave you 3 crore rupees. I told buy property on my behalf. You purchase property on my behalf, but for that beta, okay, you had to pay stamp duty and registration fees. And lawful expenses you made 10 lakhs. So can you recover it from me? Yes. Acts done in good faith. Now what is this acts done in good faith? Example, I appointed you to sell my goods. Okay, I told, okay, sell my goods. But beta, in this goods na were drugs. You did not know that they are drugs. You are acting in good faith. I told you it is sugar. I did not tell it is brown sugar. Police caught you. Then you proved that boss, okay, I did not know anything and all. But for coming out, you expended 20,000 as lawyer fees. Can you claim it from me? Yes. But if you knew about that, can you claim it from me? The principal is not liable to indemnify agent for criminal acts. Like same thing. If you knew that these are drugs, then too you decided to sell on my behalf. Okay, so can you claim indemnity for me? From me? No. Because do you remember, illegal acts cannot be ratified. Okay. Right to be compensated for loss occurred due to principal's negligence. Now what is this? Example, Mr. Harsh appointed you, X, to sell my house. Okay, so the party is my house, but I forgot to tell you that there is short circuit, okay, issue in my house. Don't switch on the lights. I forgot. You switched on the light and directly short circuit. Okay, you started doing balle balle there. Okay, so basically medical expenses were there now. Is it my duty to pay you that? Because it is because of my negligence. Am I clear with this thing? Understood? Clear? Okay. Yep. So these were the rights and duties of agent. Very simple. Next is who is liable to third parties. Now what is this? Let's understand. Sir, generally, if you are my agent, I am the principal. If you act on my behalf and there is a loss, who will be liable? Beta, I will be liable to the third parties. So generally principal is liable, but there are certain instances where even an agent is liable to third parties. So which are these instances? Let's understand. First, when is principal liable? Sir, agent acted within authority. If agent does anything within authority, who will be liable? Beta, principal. Acha, understand? Principal is liable for frauds of agent done within authority. If agent does fraud with third parties within authority, okay, for that also principal will be liable, because third party will sue the principal only. Like example, Mr. Harsh, I had a garage named as Harsh Automobile Garage. Mr. X is my agent. One day, what happens? Okay, Mr. Z comes, okay, to the garage and he demands, okay, new tire, okay, for his bike. Mr. X had a pre-owned tire, old tire, but he polished it, okay, made marks on it, and it looks like new. And he gave a old tire. Did he do fraud with Mr. Z? Yes. Now Mr. Z made a payment, take a Paytm in Harsh Automobile Garage account, obviously. After riding for some time, the tire busted and Mr. Z was injured. Now Mr. Z will sue whom? Beta, Mr. Harsh or basically X. Answer beta Harsh, na Harsh Automobile Garage. So the agent did fraud with third party within authority, but for the third party, is Harsh liable or not? Yeah. Okay. Next, if agent acts outside authority, will be liable agent. But if agent acts outside authority and acts are separable, like I told my agent to buy 1 kg apple for me, 1 kg mango for me. He purchased 1 kg apple, 1 kg mango, 1 kg orange, 1 kg banana, 1 kg chiku. Now, but is it separable or not? Yes. Whatever I ordered, okay, and for that I'll be liable. For the other things, okay, he'll be liable. Simple. Next, principal is bound by notice given to agent. The example, in the same scenario, example, that garage was on rent and Mr. A was the landlord. One day he came to X and he told me, sir, Mr. X, you are the agent of Harsh. From next month, the rent rather than 10,000, it will be rupees 12,000. Okay. And he informed X. Now after 5 days, X did not inform me, but after 5 days, X left the agency. Okay. He discontinued agency. Okay. And now beta, I am sitting in the garage. After a month, next month beta, when A comes to collect rent, I gave him 10,000. He told 12,000. I told no sir, 10 no. He's like, no, I told your agent that rent will be 12,000. I'm like, okay, he did not inform me. Okay, you should have informed me, sir. Okay, he did not inform me, so I'm not bound to pay. Am I bound to pay 12,000? Yes, because beta, notice to agent is notice to principal. Section 229. Okay. Next, so what is this? Principal is liable for acts of agents outside authority if principal represented third party that the acts are within authority. This is agency by estoppel. That Urfi Javed wala. Will I be liable to Niranjan or not? Third party. Yes. Am I clear with this thing? Okay. Not Niranjani. X tha na, Mr. X. Okay. Now, so these are the circumstances where principal will be liable. Sir, but sir, what are the circumstances where agent will be liable? The agent is liable if agent exceeds his authority and the same is not divisible. Like I told, bring me 1 kg apple, 1 kg orange. ये भाई साहब मिक्स फ्रूट्स लेके आ गया, ठीक है, मिक्स फ्रूट जूस. ओके, और he brought salad, mixed fruit salad. So now beta, is it divisible? No. Now beta, if I accept the whole, I'll be liable, but if I don't accept, which generally I'll not, so who will be liable? Beta, agent. Now working for foreign principal or for foreign sovereigns. Now do you remember in foundation, you are in foundation. In your general part, we studied better essential elements of valid contract, capacity to contract. In that person disqualified by law, in that last point was foreign sovereigns, foreign ambassadors like Joe Biden and all. I told if Donald Trump comes in India, okay, he can contract, but if he doesn't perform the contract, can we sue him? Answer is no, until central government allows. So actually it is not like central government should allow. It is a rule that if foreign sovereigns come here, okay, foreign representatives, foreign brand ambassadors, not brand, foreign ambassadors, sorry, when they come here, okay, they contract, it is mandatory that they should contract only through an Indian agent, because we can't file a suit on them, but we will file a suit on whom? Beta, Indian agents, so that Indian agents will be personally liable. Okay. Next is working for undisclosed principal. Now, what is undisclosed principal? Let's understand. See, whenever you are working as an agent for undisclosed principal, you will also be liable to the third party. So what is undisclosed principal? See, yes, there are three types of principal under Indian contract. First is disclosed principal. What is disclosed principal? Like Harsh appoints you, Sir X, as my agent to sell goods to third parties. You sell goods to third party telling you are the agent and Harsh is the principal. Did you disclose? Yes. So in case the goods are damaged or there is a loss to third party, who will be liable? Beta, principal, not agent. Unnamed principal. Unnamed means you sell the goods telling you are the agent, but you don't tell the name of the principal. When there is any issue, like if the goods are faulty, there is a loss to third party, that time you disclose it. So basically for unnamed principal also, beta, who will be liable? Beta, principal, because you told na, ki boss, I am working for the principal, I am not the principal. But undisclosed principal. Now what is undisclosed principal here? See, generally now what happened, ki my name is very defamed in the market, nobody beta purchases goods of mine. What? But you are a very famous agent. People trust you. So I come to you and I tell you, can you sell goods of mine? Rather than 10% commission, I'll give you 20% commission, but there is a condition. You tell why, what happened? So I tell you, you have to do one thing. You have to sell the goods to third parties telling it is your goods. You are only the principal. You told, okay, 20% I'll do it. Now tell me here, are we doing fraud with the third party? Yes. When third party comes to know about that, he can sue the principal as well as agent. Here agent is also liable. Basically working for undisclosed principal. Agent is also liable. Am I clear? Understood? Good. Now, the next. Sir, in case a person pretended to be an agent, like Preeti pretended to be my agent. Okay? So basically I have two options. First, I can ratify the act. I tell, Preeti is my agent. So basically now beta, I'll be liable in 233. But if I say no, she's not my agent, there are the generally who should be liable? Beta, Preeti should be liable. But what is written? Beta, both are liable to third party. When sir, when both are liable to third party, this is made on an assumption. If I also represented somewhere to the third party that Preeti is my agent. Like example, I understood that Niranjan is also diamond merchant. He thinks that Preeti is my agent. So I told Preeti, do one thing, you buy a diamond on my behalf, and later beta, take care, when he comes to me, sir, you give the payment. I will be like, see, Preeti is not my agent. See the contract, she is not my agent. She is just a valuer. Okay, that means we both are doing fraud with him. Okay, in this situation, okay, will we both be liable to the third party or not? Yes. So section 235 is made on that assumption that boss, if both are involved, okay, in doing some wrong act, okay, then beta both will be liable. But beta, in case I was not involved at all, so basically who will be liable? Only the third party. Sorry, only the pretended agent. Am I clear with this thing? Understood properly? Clear? Did you understand everything up till now? If yes, give me a thumbs up quickly. Good. Good. Now this is exception. This I'll do after sixth point. So what does this point say? Person acting as agent is in fact the principal. Now see, I am very smart guy. What I do now? I am Harsh. It is my goods, but I sell the goods to third party, telling that I am the agent. Mr. X is the principal, but X is not there. There is no person like X, because tomorrow if the goods are defective, third party will try to sue X, and I'll say X ran away maybe. So basically it's fraud. So basically when people come to know that boss, it's my goods only, I am the agent, I am the principal, basically I'll be liable to them. Now fifth point is an exception, beta 234. Here neither the principal neither the agent will be liable to third party, because third party is trying to do fraud with us. So see, what is this? No certainty as to liability. See. Now what is this? Example, A appointed B as an agent to sell some goods to C. Now sir, in case the goods are defective, who will be liable? A. But what C does now, he enters into a contract with A and tells ki, sir, in case defective goods, you will be liable, and same contract he does with B, you will be liable. So two times he is taking liability, the damages basically. Can he take damages from both the parties? No. So is he doing better, take a fraud with us? Yes or no? Okay, who will take the liability in case of defective goods should be certain. You are telling both the people should be liable. It is not possible. So basically here both will be exempted, both will be discharged. Understood properly? Clear? Okay. So this is where beta liability of third parties, liability of principal and agent to third parties come to an end. Okay. I hope I'm clear with this. Perfect. Now the last part we have to do. Okay, we understood who's an agent, who's an principal, what are the types of agent, sub agent, substitute agent, everything, rights and duties of agent, who liability towards third party, every damn thing we studied. Now beta, the last thing is revocation of agency. Sir, under which circumstances beta, okay, contract of agency will come to an end. So now there are two things. First is beta, contract of agency will come to an end first by act of parties. Parties will only do it, cancel it. And second beta, by operation of law. Law tells if these things happen, then the contract of agency will come to an end. Now which are the situations? Let's see. The termination of agency. First is by act of parties. First is mutual agreement. Can beta agent and principal both tell we don't want to continue with each other? Yes. It is kind of rescission, okay, which we studied. Next, revocation of principal. By principal. Can principal tell the agent I don't want your services? But beta, in case of irrevocable agency, principal cannot cancel the agency in between. I'll tell you what is irrevocable agency. Sir, can agent tell the principal I don't want to continue agency? Yes. Next. So basically both can do, principal can do, agent can do. Compensation for revocation, section 205. Now what does this point tell? Sir, if the agency was for a fixed time, like 5 years. Now in between, before that, if principal or agent revokes the agency, the breach of contract. So the person who's revoking the agency has to pay compensation to the other party. That is section 205. Am I clear? Next, notice of revocation or renunciation. It means beta, sir, in case agency was not for a fixed time, so any party can cancel the agency, but you have to give a reasonable notice. Okay, generally the notice is of 1 month. Okay, without reasonable notice, without giving notice beta, if the other party terminates the agency, like agent terminates agency, so he has to pay compensation to principal and vice versa. Like when you go for a job beta, at that time if you change the job, at that time also you also have to give notice, no? Same thing. Yeah. Revocation and renunciation may be expressed or implied. Like you can expressly tell कि sir I don't want to continue, or it can be implied. Implied means example, okay, Harsh and X was the principal and X was my agent. So basically there is a contract that Mr. X can be agent of mine and he cannot be agent of any other person. Example, X acted as a agent for Y also. Y is also the principal. So it is implied that he doesn't want to continue with me. Am I clear? That is the point. When termination of agent's authority takes effect, like one more example. The example beta, I am McDonald's. I give franchisee Mr. A. If he wants to discontinue, he can expressly tell, or else he closed that shop only. It is implied he doesn't want to continue. When termination of agent's authority takes effect as to agent and to third person, it is very important. Section 208. What is this? See example. Mr. A as an agent X. X sells goods to Y. Now I decide today on 29th. Today is what, 28 or 29? 28 November 25. That I don't want to continue with X as an agent. Okay, his agent is third party. Now, so I send letter to X. Hey boss, from today you are no more agent. And also to Y, Mr. X is not my agent, don't buy from him goods. But this letter reached to both of them on 2nd December. So from which date beta, take a for X and Y beta agency came to an end, 2nd December. And they actually received it, not before that. Okay. See, the termination of authority of an agent does not, so far as regards the agent, take effect before it becomes known to him, or so far as regards third person before it becomes known to them. Next is, sir, when will the contract of agency come to an end? By operation of law. Law tells if these things happen, a contract of agency by default comes to an end. First, by performance. I appointed you to sell my house, you sold my house, khatam. There is no agency now. Expiry of time. I appointed you as my agent for 1 year. It's been 1 year. Now you are not my agent. Death or insanity. Okay. Like sir, if the principal dies, will the contract of agency continue? Answer is no. If agent dies, no. It will not continue. Agent is not there. But beta, in case it is an agency coupled with interest, then death of principal does not affect agency. Sir, what is agency coupled with interest? I'll tell you the last thing, don't worry. Sir, insolvency. Sir, if principal becomes insolvent, will the contract of agency continue? Sir, if agent becomes insolvent, then will it continue? Now here law is silent, but many courts have told if agent becomes insolvent, then at that time also better agency should come to an end. Law is silent, so you also have to write the same thing. Take a when question comes. Insolvency of principal puts an end to relationship of agency. There is nothing mentioned in the contract act regarding insolvency of agent. Our courts have accepted that insolvency of agent also terminates agency. Next, destruction of subject matter. Now, what is destruction of subject matter? I appointed you as an agent to sell my car. My car met with an accident. Obviously, now beta there is no agency required. Parties becoming alien enemies. Okay. Obviously, X and Y were I was his principal. He is agent. He is Indian. He is Chinese. Everything was good. Both were happy. But beta India China went into war. Now beta can Y be the agent? No. Contract of agency come to an end. Now, okay, section 202, irrevocable agency. Now, what is this? See, understand. I told you that I'll tell you about irrevocable agency. Sir, can principal cancel the agency? He can give notice and cancel the agency. But in case it is an irrevocable agency, then, okay, then beta, okay, this agency cannot be cancelled. It will not come to an end. So there are three agencies which are irrevocable agency. First is agent has incurred liability. Now there are some agents now called as del credere agents. What del credere agent do now? Example, I am the principal and X is my del credere agent, DCA. What he does, beta, he purchases goods on my behalf from Y. And what does he tell? Give the goods to Harsh. Okay, Harsh will make payment. Okay, In case Harsh doesn't make payment, then I'll make payment. He takes personal liability. Did you understand? Now tell me, example, I got the goods. Now I should pay. But before that I told, Arey, okay, thank you X for your services. I want to discontinue with the agency. Arey, but if I discontinue the agency, who will pay for this? So basically, without paying, can I discontinue the agency? Next, agent has exercised authority and obligations have arisen. Like example, I run my own classes. Example. And JK sir told ki, Har sir, okay, you be our agent for CA lectures. I run 11-12 standard classes. Bola ki sir, you be our agent for CA lectures. Okay, you start CA foundation. I told, but sir, I don't have faculties. No, we'll send faculties. Don't worry, you will be our agent. I told, okay sir. So I started doing advertisement and all. Okay, they only paid for advertisement. Students came. Okay, now beta, I started teaching law. Okay, I started teaching law. Okay, I'm acting as an agent. Now JK sir tells me we don't want to continue the agency. Now tell me beta, I have to finish the syllabus. Now obligations have arisen to finish the syllabus. Now beta, without finishing the syllabus beta, can JK sir beta cancel agency? No, they have to send the faculties and cancel agency after finishing the syllabus. Am I clear? Understood? Next, agency coupled with interest. Now what is agency coupled with interest? Understand. Example, Niranjan and generally he takes loan from me. I'm a person who gives loan and all. Every time he repays on time. This time what happened? He took loan from me for 6 months, 30 lakh rupees. And he did not repay me. So I went to his place. I told, this is the first time he did not repay the loan. What happened? He took me to a godown. And he showed me in the godown there were the whole godown was filled with coconuts. I'm like, what is this? So he told, sir, I decided that boss, I'll buy these coconuts. For that I took loan, put my money also, and I'll sell it, okay, for double price, 100% profit. But for selling coconuts, I did not get any agent only. So now I have coconut worth 1 crore. Now what to do, sir? I don't have money to pay you. So there was a room inside. He told me, sir, in that room there are coconuts worth 30 lakhs. I can't pay you 30 lakhs, but you can take the coconuts. That are your coconuts. I told he, you didn't get agent to sell coconuts. You should have called me. I can sell coconuts. I have a business of that. So what he told, he said, do one thing. You sell this whole coconuts. Okay. Where 30 lakhs of coconut is yours only, mine only. And you take your 30 lakh rupees plus you take the commission of selling the coconuts. Which commission I pay to others like 5 lakh rupees. So I told, okay, now tell me, I am appointed as an agent to sell something where even I have personal interest. 30 lakhs coconut is mine only. Yes or no? This is called as agency coupled with interest. Now tell me, if Niranjan dies, the principal dies, will the contract of agency come to an end? No, because 30 lakh worth coconut is mine also. I'll sell all the coconuts, take my 30 lakh, 5 lakh commission, rest of the amount I'll give it to Niranjan's legal heir. Am I clear with this thing? That is agency coupled with interest. Understood? This is irrevocable agency. Clear everyone? So here contract of agency also came to an end. Thereby special contracts. I hope you understood everything. Yes. Give me a thumbs up quickly if you understood everything quickly. So basically that's it for the day. I hope I told you how to write answers also. Okay, so that's it for the day. Tomorrow last lecture, okay, we'll finish partnership, which will take three and a half hours. 1 hour for LLP and 1 hour for Indian regulatory framework. Okay, so tomorrow we'll finish it. Bye bye, take care, bye. Study well.